All right, says we're being live streamed. Great. I think it's great. Now I have to drink my coffee with care.
You are the host now.
Thank you, Anna. Have a great day. Miss Olson, are you there?
Yeah, hearing examiner Lennon, I'm here. I'm just doing a little bit of.
Well, we lost you. Hi there. What happened? Pushed
I
the
don't
wrong.
know. All of a sudden, something happened and I closed myself out of the meeting somehow.
Well, it's okay, unless you're in the middle of testimony or something like that. We can't talk about the merits because we have these ex parte rules, but we can talk about purely procedural stuff, even without the other parties present. And I just wanted to fill you in that I sent an email to Mike Smith, who's the general counsel for this commission. I don't know if you know, I can go talk to the commissioners, but it really doesn't work that way at all. I have to talk to their lawyer. And I've got an email into him and he hasn't yet responded. That was only this morning about 7:54. He might not even checked his emails yet. He would probably delegate it to another assistant general counsel and they would prepare some type of order and present it to the commission. Today is hearing day. So unfortunately that didn't work out too good. I don't think it's going to happen today. It might happen next week on next Wednesday, or they can actually do like a single signature order during the week. They just present it to one commissioner. I'm going to ask, I haven't really given him a number of days, but I was thinking 45 or 60. Do you have an opinion on that?
Yeah.
Minimal, I know.
Well, to be honest, I think that I don't think that we've asked for or agreed to pay for expedited transcripts in this hearing. I think Mr. Lee may be able to clarify that. I think he works directly with the company on that. So contemplating from, I think it's usually like 10 days. Unfortunately, the hearing's longer than I think any of us anticipated. For him to get the transcripts. And then I think I understood from reading testimony that the contested issues in this case are pretty limited. So I think I would hope that maybe we could limit post-hearing briefing to specific contested issues, in which case I think we could get it done quickly. And, you know, it's nice to have time to do a brief and a response, but I can also take direction from you. We certainly need to give you time to do a report and you know, that is something that's very important, and we don't want you to feel under the gun because,
Well, I have other cases, which is the problem. It's not just this one.
no, I
Things
appreciate
come
that.
up.
Very busy, and so the company doesn't want to act unreasonably and force you to try to do something that you simply don't have time to do. So you tell me the time that you need. I can send a quick text message.
Well, you kindly and I think diplomatically and I think correctly agreed to an extension of the minimal extension, I think were your words. And I've already talked to Mr. Lee a bit this morning, and I've already emailed and I talked to him. And I talked to Anna, who is, I don't know if you know Anna, she's our legal assistant. She keeps track of our funding. We have a certain amount of, taxpayer money for this kind of stuff. And unfortunately, we do not have money to pay for an expedited transcript. It's not, that's not really the problem in the case. And I haven't asked you to pay for it, but that's not really the problem. That's not where the problem lies. Who else is online here? It's just us three. Mr. Lee can hear us speaking. I think we are actually on YouTube as well right now. So I'm careful to discuss with you any things which are not merits of the case. And sometimes that line is a little fuzzy. I think we haven't discussed any merits of the case. I really think 45 days would be completely sufficient, and that's the minimal. 60 would be even easier. So that's kind of where I am.
So let me just think for a second. That would be 60 days from approximately January 24th.
I think I came up with January 25th, but it's kind of fuzzy also, one day before, one day after.
Yeah, so that would put us like with a final order. The commission would have to issue a final order by, say, like the second week in March. Under 60 days. Am I getting this right? No. January 24th, February 24th, March 24th. So they would have to issue a final order by the end of March. At a calendar here.
Yeah, it would probably be March 23rd or March 30th that they would do it on a Wednesday.
I think that so that would mean, I don't know if you're intending to allow time for exceptions. You would have to have a report by the beginning of March. I think we could certainly work with that time schedule.
Even now that you mentioned, now that I see it, it really needs 60.
Yeah, I think you're right. If you don't mind, I'll just send a quick message to EPE. I can't imagine that we would oppose it, because I think that still puts you under the gun to try to get this and the commission resolved as quickly as possible. And so I can't imagine there's any objections.
Yeah, well, these dates today and yesterday were submitted as an agreed dates from the parties.
Right.
You remember that. So I think that's important to keep in mind. Who is Amy? Oh, Amy Martin, you're the next witness, I think, for El Paso. Hi there. Wow, it's nice to see a face behind the name. Up till now, there was none. Mr. Dunn, if you were wondering, we were discussing purely procedural stuff, Miss Olson and I, because she's the applicant, so lawyer, and the moving party. She has the most at interest for any extension of the deadline, and that's why I was talking to her. I just had an opportunity to have a few moments, and I don't like to waste time, so that's what we were doing there.
Well, time is always invaluable, so I can always certainly appreciate that, Mr. Hearing Examiner.
Thank you, sir.
I've just sent a message, and I'll let you know as soon as I get confirmation. I can't imagine that we would have any objection to that. It seems really reasonable to me.
Yeah, you know what I was doing, Miss Olson, is it's the way us lawyers think. I was drawing a little flow chart of what would happen if you prevailed, that way. It would not go well. There would very likely be appeal, and it would be just a disaster.
Yeah, I agree. The commission has no interest in creating unnecessary issues. Yeah, and they just responded. That's fine.
Okay. Hi, Mr. Black. How are you this morning?
I'm fine, thank you. How are you?
Pretty good. I want to, I guess the word is disclose, but disclose to you, I've had about a 5-minute conversation with Ms. Olson, but only about procedural matters, specifically the length of any extension of the suspension of the tariff. And I've actually been communicating with, I sent an email to Mike Smith, and I know he's probably really busy today on, meeting day, so he may not get back to me, but I'm looking for an order from the commission. And I think I have to go through OGC to get one. Anyhow, that's what has happened in the 5 minutes since I've been talking with Ms. Olson. Nothing mayor-wise. Hi, Ms. Stevens. How are you today? Can't hear you.
Good morning. I'm fine, except Lisa sent me a message a few seconds ago, and she may be having trouble getting in again.
Yeah.
I keep sending her the same. It's the one that it's in the order from you, the last order from you. Anna sent it. It works for me. I don't know why it doesn't work for her.
Maybe she's putting a period after the URL or something.
I know that Zoom wanted to update me when I came in this morning, and I got a little frightened about that.
No, I don't think they didn't ask me for that. So, well, anyhow, we've had Ms. Olson and I were just briefly discussing the length of any extension I might get from the commission. You didn't miss anything, but it was purely procedural, and we kind of. So I kind of suggested 60 days, and she kind of agreed to it.
I see Lisa.
There's
We're
Lisa.
good.
Hey, Miss LeBroke, what did it take to log on? Or did you find out why you had a little issue? Maybe she doesn't have her
It
audio.
says she's connecting to audio, so maybe she's still working on it. Hi, Lisa. Can you hear us? Why don't you put on your audio so we can test, since you've had problems before?
I'm good.
All right.
Wonderful.
Hi, it is 10:01 a.m., which is our start time, and we are being broadcast on YouTube. So, Ms. LaRoque, what was the problem connecting? Did you ever figure that out? It'd be nice to know.
It wanted a password, or not a password, a meeting code. And
No, yeah, I hear you. That doesn't make any sense at all, actually.
that happened to Phil as well.
I don't know why. I honestly do not know why. Let's see, who are we waiting for now?
Miss Lynch.
Yes, exactly. Ms. Lynch. Thank you. So we're not going to start without all counsel of the parties present. Well, I don't want to waste any time too, so I'll just make a few procedural comments. Ms. Stevens, I don't know how to put this, but I'm going to try. I'm going to diplomatically ask you to limit your cross-examination as much as possible.
I am trying. I've gone through it like 3 times to try to cut it down.
Yeah, I kind of did a mental review of what took all the time yesterday, and that was, your cross, and I'm not trying to limit you, but if you would please make an effort. The reason I'm saying that, I also think we have 7 witnesses to get through today.
And Mr. Lennon, to be optimistic here, I was looking at the transcripts from the case 3 years ago, and it turns out Ms. Perea testified all during the first day, and we got the rest of the case done the second day. So do not despair.
Okay, thank you. There's Ms. Lynch. Okay, are all the parties present? We've got Mr. Simpson, we've got EPE. I think we're all here. Okay, good morning, everybody. Are you ready to go on the records? I think the sooner we start, the sooner we finish. Okay, Mr. Lee, please begin the record. On the record and on the YouTube broadcast, good morning, everyone. My name is Robert Lennon. It is 10:03 a.m. This matter is scheduled to continue today at 10 a.m. Some of the parties have been logged on, but we have not been on the record. There have been no discussion of the merits. There has been a brief discussion about the possible commission order, how long it should be as to extending a deadline. That was purely procedural. And then there's been a discussion about trying to limit the cross-examination of witnesses, if possible, as much as possible, so that we can get through about 7 witnesses today. The goal is obviously to conclude today. I'll try to keep my talk to a minimum in an effort to complete 7 witnesses. We will be taking breaks, if possible, every hour, specifically to give us all a break. And also, Mr. Lee, we'll talk about a lunch break. Maybe we'll limit it to a half hour. We can talk about it at some time, probably around 1 o'clock-ish or so between witnesses. I am ready to continue with the hearing begun yesterday. I should mention for the record, this is New Mexico Public Regulation Commission, case number 21-00114UT in the matter of El Paso Electric Company's application for approval of its 2022 through 2024 energy efficiency and load management plan. And I think we are ready to go. Is everybody ready to proceed? Okay. I believe Ms. Olson is about to call her next witness. Is that correct, Ms. Martin?
Yes, that's correct. EPE calls Amy Martin as its next witness.
Mr. Lee, would you please swear in the witness? Where is she? Oh, there she is.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Your witness.
Good morning, Ms. Martin. How are you today?
Good morning. Yourself?
Pretty
Okay.
good. Will you please state your full name for the record and spell it?
Amy D. Martin, AMYD-MARTIN.
And can you please state your current profession?
Yes, I am Vice President of Consulting and Engineering at Frontier Energy.
And do you have before you what's previously been marked as EPE exhibit number 3?
Yes,
And do you recognize that document as your pre-filed direct testimony?
yes,
And was that direct testimony drafted by you or under your direct supervision?
yes,
And do you have any corrections to your direct testimony?
no,
Is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
yes,
If you were asked these same questions today, would you give these same answers under oath?
yes,
Mr. Hearing Examiner, EPE offers EPE exhibit number 3 along with accompanying exhibits.
Thank you, Ms. Olson. Mr. Black, any objection?
No objection.
Thank you. Ms. Stevens?
No objection.
Mr. Simpson?
No, sir, no objection.
Okay. Ms. St. Lynch, any objection?
No objection. Thanks.
Thank you all. And thanks for a great job of unmuting yourself before I ask you. That's nice. Well, there being no objection, the direct testimony of Amy D. Martin on behalf of El Paso Electric Company dated July 15th, 2021. No corrections, no changes is admitted into the record. It's now evidence and will obviously be considered. Ms. Olson, are we ready to have cross-examination?
No, Mr. Hearing Examiner, we still need to admit her, have her adopt her rebuttal.
Okay, go ahead.
Ms. Martin, do you also have before you what's previously been marked as EPE exhibit number 4?
yes,
And do you recognize that document as your pre-filed rebuttal testimony?
yes,
Was that rebuttal testimony drafted by you or under your supervision?
yes,
And Ms. Martin, did you have any corrections to the declaration that accompanied that testimony?
Yes.
And can you please just identify those corrections?
I believe there was, I apologize, I don't have them lined out, but I think there was a mistake. It was referencing my direct testimony. Is that right?
Yeah, I think the caption and the paragraph 3 of that declaration referenced your direct testimony, but was it your intention that that was a declaration submitted in support of your rebuttal testimony?
Yes, it should be in support of my rebuttal testimony.
Okay, and so for the record, we're changing the caption and paragraph 3, instead of saying the foregoing direct testimony, it should say the foregoing rebuttal testimony. So strike the word direct and replace with rebuttal.
What page are you on?
This is the declaration at the end of the testimony. It doesn't have a page number, but
Okay.
directly following page 12 of Ms. Martin's rebuttal testimony.
I'm trying to be electronic like everybody else and get it up on my screen.
I would imagine it's about page 15 of the PDF.
Okay. All right, thank you. You can continue, please.
Okay, and aside from the corrections to the declaration that we just discussed, do you have any other corrections to your rebuttal testimony?
No.
And is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes.
If you were asked these same questions today, would you give these same answers under oath?
Yes.
And Mr. Hearing Examiner, El Paso Electric offers EPE exhibit number 4, the rebuttal testimony of Ms. Martin with the corrections to the accompanying declaration that we just discussed here on the record.
Mr. Black, any objection?
No objection, Your Honor.
Thank you, Ms. Stevens.
No objection, except I would like Ms. Olson to clarify. I'm looking at it, that those changes were done without redlining in the version that we received electronically last Monday evening, because that's what I'm looking at. I don't.
To be honest, Ms. Stevens, I'm not sure that those corrections were made in the version. I think the correction in the caption is something that I just realized after we had circulated the version.
The caption or the title of the declaration?
I'm referring to the underlined bolded, not the case caption, but yeah, the title of the pleading.
Yeah. Okay, the version we received already has those changes made.
So it says the foregoing rebuttal testimony.
Yes, both in the caption.
Yeah, that's
and
what it says.
3.
Okay, I apologize. So those changes might just not be in red line, but it was an inadvertent error. The pre-filed testimony, the declaration says direct, and the corrected version says rebuttal, and it should be rebuttal.
Thank you. I appreciate the clarification. I'm confused a lot of the time with this stuff.
And there's no objection, Ms. Stevens?
No.
Mr. Simpson?
No objection, Your Honor.
Last but not least, Ms. Lynch.
I don't have an objection, but I am struggling within the EPE's download share file documents to identify the direct testimony and the rebuttal that Ms. Martin may have written. In the file link, I'm directed to Schichtel Direct.
So
It's the old one.
Ms. Lynch, we inadvertently sent the incorrect share file link, and then about maybe 10 minutes later, you should have received an email from Teresa Pacheco providing the correct link. And so it sounds like you have the incorrect link.
Okay. I can navigate this. I don't want to take anybody's time. Thank you so much.
Sure, and I'm happy to resend the link if that would be quicker.
I think I've got it here. I see it's just down beneath.
Okay.
Thank you.
Ms. Lynch, any objection to the admission of this document as evidence?
No.
Thank you. There being no objection, Amy Martin's rebuttal testimony. Hold on a second, I just lost it. Okay, dated January 5th, 2022 is, and labeled as EPA Exhibit 4 is hereby admitted into evidence. Next, Ms. Olson. Anything else?
Mr. Hearing Examiner, those are the exhibits that Ms. Martin is sponsoring, and at this time we tender her for cross-examination.
Thank you, ma'am. And I'm going to start with Ms. Stevens again, but I had actually asked Ms. Stevens off the record if she would kindly try to limit her cross-examination, if at all possible, so that we will get through 7 witnesses today, and she kindly intends to do so. Please proceed, Ms. Stevens.
Thank you. Good morning, Ms. Martin. Nice to see you again. It's been 3 years.
Good to see you too.
Where are you occupied? It looks like you're in a locker room or something.
This is a very nice Zoom background I found on Google. I'm in my guest bedroom at my home in Austin, Texas today.
And it looks like you're in a gym or something. So I'd like you to turn, you do have a set of exhibits that were circulated by the city on Monday, do you?
Yes, ma'am.
I'd like you to turn to CLC Exhibit 15, please. And you sponsored this discovery response, did you not? Discovery response as 2 of them.
1 second, I apologize. It's
15.
This is our response to CLC 2-1 through 2-6. Is that correct?
It's actually, if you look at the document, it's an excerpt. It's 2-1 and 2-2.
2-1 and 2-. Okay. Yes.
So you did sponsor those answers?
Yes, ma'am.
And 2-1 asked for the, if you look at 2-1, this is the first page, asked for the calculation in executable electronic format, the calculations of the utility cost test or UCT for each proposed program, right? The response is, please see objections. So were you familiar with the objections when you wrote this response?
I believe the objections were written by our legal team.
I understand that they were written by the legal, but were you when you answered the response, when you answered the question, were you familiar with the legal objections that were going to be made in connection with your response?
I was familiar with the conversations we had, but I can't say for certain that I knew exactly what that language would be or what those objections exactly were at the time I wrote this response.
Would you turn to CLC Exhibit 25?
Give me a minute too, Ms. Stevens. Every time you change the documents you refer to, it takes me a minute or so to find them.
Yeah.
Sorry.
And that one should be in my the third set of exhibits that was labeled erroneously labeled second set, but it would be the 20 through 29 or whatever.
Okay, I think I have 25 on my screen. Please proceed.
So Ms. Martin, you said that you were familiar with the nature of the objections. You helped with those objections. Did you help identify what to object to regarding that answer before?
Okay, there was an objection. It's overruled. I understand the way Ms. Stevens' cross-examination is cross-examining this witness. So you can proceed, Ms. Stevens.
Okay. So did you assist the company in identifying what was what?
Objection,
what-
this is going to privilege.
I am asking, oh, I'm sorry, make your objection, but I'll have an answer to that. I'm just asking her whether, not what she did. Okay.
Attorney-client privilege, that's your objection, Ms. Olson?
Yes, Ms. Stevens' question is commenting on communications she had with counsel in developing objections to this discovery.
Okay, well, first of all, thank you, and I appreciate the quick objection, but Ms. Stevens hadn't finished her question yet.
Yeah.
And when I prepare a witness to testify, I tell them to take a deep breath before they answer and to wait a second to see if there's any objections. I don't know if you do that, Ms. Olson, but I'd like to hear the question before I hear the objection. So I'm going to let Ms. Stevens ask the question. I see this as basically not impeaching particularly the veracity of the witness, but attacking the reliability of the answers to interrogatories. In other words, whether this declarant, if you will, on the answers to interrogatories actually knew what she was signing. And I see that actually is a valid cross-examination. So I'm going to let her proceed. Go ahead, Ms. Stevens.
So Ms. Martin, did you, I'm not going to ask you how you communicated. I just want to ask you whether you were in communication with the company to help them with these objections, and then to, for you to answer subject to these objections. Were you in communication with them? Was this generated as a collaborative document?
Yes, I did not write it, but yes, I did interact with them.
And have you seen it before?
Yes.
The city moves to admit CLC 15 and CLC Exhibit 25.
And let's see if there's an objection. Ms. Olson.
No objection.
Mr. Black.
No objection, Your Honor.
Excuse me, Ms. Lynch.
No objection.
And Mr. Simpson.
No objection, Your Honor.
Okay, I didn't print them out yet, but we are going to admit what is labeled CLC 15 and labeled CLC 25. Now it's in the evidence. So please proceed.
Okay, so now let's go, now that we've dealt with the objections part, let's look at your response, because this is your work. So we have the question, and we're looking at CLC Exhibit 15 now, Ms. Martin. So the question asked for the calculations, is that right?
Correct.
And the response, the first line of the response is, please see objections. The second line of the response is, the UCT calculation is defined in the EUEA and described in your direct testimony. Did the city ask for a definition or description of the UCT calculation?
No.
The next paragraph there says that UCT calculations, data inputs, and sources for each proposed energy efficiency and load management program are summarized.
Sorry, data inputs and sources.
Inputs, let's see, data inputs and sources for each proposed energy efficiency and load management program are summarized in witness Martin's testimony and provided in the ADM work paper, ADM-1 work paper. Can you tell me whether the city asked for a summary of your calculations and inputs?
No.
Okay. And can you show, in looking at this word provided, can you show me where in Exhibit ADM as part of your first, your Exhibit 1 EPE, your direct testimony EPE Exhibit 3, can you show me where in ADM 1 the calculations are provided?
Yes, the calculation outputs are provided in the cost effectiveness summary tables for every program and the overall portfolio.
Did the city ask for the calculation outputs or the calculations, Ms. Martin?
Objection.
Well, I don't want to hide the football from this witness, Ms. Stevens. I'm looking at ADM 1, page 86 and 92. It says cost effectiveness inputs. So, it seems there are some inputs already there. So, let's not try to trick her. If they're there, they're there. You can refer to the page.
Yeah, I'm asking about the calculations, not the inputs. I agree that they've provided the inputs. I'm asking about the calculations.
I think you asked if there's anything other than the outputs.
Yeah, if I
the inputs.
apologize if I asked the question in the in the conjunctive, but the question is, where in your testimony, where in that exhibit ADM 1 are the calculations?
Please answer, Ms. Martin.
I may be misinterpreting the term calculations. Can you please describe, are you asking for the formula?
Okay, normally the witness doesn't ask the question, so sorry about that, but I can ask Ms. Stevens to be more specific. Are you looking for like a pluses and minus and the product of the two multiplicants, that kind of language?
I am looking for the calculations, yes, not the end result of the calculations.
Okay, well, these days people put them as the behind the little box in their Excel spreadsheet as the calculations, and that's the world we live in today. And,
well, the question, I don't want to be arguing with either you or the witness here, but let's go back to, may I go back to the witness? With that, I think that would be safer.
You're not arguing with me, and
I hope I'm not. I don't mean to. I feel like I am. So Ms. Martin.
You may continue, please.
Is it your view that a calculation is the end result single number of a series of calculations? Especially given that the question asked for the calculation electronic executable format, would we have needed an electronic executable format if we only wanted the numbers that are in the ADM 1?
Objection. That was several questions.
Okay. What is your definition? What is your definition of a calculation, Ms. Martin?
Taking a series of inputs and using a formula to produce outputs, all of which have been provided in ADM 1, I believe.
Where's the formula and where are the calculations in ADM 1?
The formula used is the utility cost test. It's a publicly available calculation. The inputs are provided in ADM 1. And the final UCT results are provided.
And where is the calculation? Where is your calculation?
We calculated the UCT as a hearing examiner referenced in an Excel-based Frontier proprietary model.
Did the objection say that you would not produce it because it was a proprietary model?
Mr. Hearing Examiner, Ms. Stevens appears to be litigating a motion to compel regarding production of documents in response to this discovery request. We've already addressed that before the hearing. This does not seem to be cross-examination on Ms. Martin.
Okay, I'll move on. I think that. But I did want, if there's anywhere in ADM 1 there, that Ms. Martin, if there's anywhere in ADM 1 that you would consider to be a calculation, I would like you to alert me to, alert us to that portion of your testimony.
The objection is sustained. Ms. Stevens, I remind you that you agreed to move as quickly as possible today. And I would appreciate that you would do that. And I would tend to agree. I don't think there's any misunderstanding as to calculations, and they're either there or not. And Ms. Martin is doing the best she can. I ask you to just keep the cross-examination moving. Thank you.
I'll go back to the discovery response then, Ms. Martin, if I can find it.
Which one?
The CLC Exhibit 15, it's a response 2-1. So the example you give is, and this is a reference to a specific page of ADM1, is and it would be, let's see,
Table 911.
Pages 21 of 23, I believe, of the ADM1. So we're on page 2 of 2 of the discovery response, the last line, example 22, UCT benefit cost ratio calculation. But I think that you were referring to tables 9 through 11. Is that pages 21 to 23 of your exhibit ADM1?
I have it as 19 through 20.
Maybe I have the wrong ones.
19 through 20, which is table 9, table 10, and table 11. And like I said, we're not going to have a discovery hearing here. We're going to cross-examine this witness.
Let's go to tables 9, 10, and 11, which you cited, and just wish to ask you for one more number. I'm having trouble. Are these the tables? 9, 10,
So what is the question?
so, Ms. Martin, is it reasonable? Are the numbers that you I'm not at tables 9. Okay. The numbers that you use in this example of a UCT calculation discovery response, should I take the $135,000 figure to be a rounding of the $134,991 on table 12 as the total annual program costs? Is that what that represents?
Correct.
Okay. Now, where in your exhibit ADM1 is the calculation of the $147,000 of savings, benefit, lifetime benefit?
Those benefits are a product of the measure level energy savings. So that is the output. The $147,000 referenced is the output.
So you're saying that's an output of the calculations or the spreadsheet, the formula that we don't have, was not given.
That is the output of the calculation. Yeah.
Okay. Thank you. So if you turn back to your direct testimony, please, the start of your direct testimony, on page 3, lines 3 to 4, you're the sponsor of this plan document, right?
Yes.
And does this plan, is it your understanding that this plan is the plan that the commission will approve and will become the basis of the programs for the next 3 years?
Yes.
Okay, good. And then on page 4, you talk about, the heading is program analysis and validation. And your answer in line 5 is Frontier worked collaboratively with EPE to analyze potential modifications, consider new programs, and conduct the analysis. Several times throughout your testimony, you refer to collaborations with the company. So I guess would you please describe briefly for me the nature of the collaboration? What steps what Frontier was responsible for? What information or decisions the company was responsible for?
Yes, if you look at my rebuttal testimony, starting on page 3, I provide a graphic that summarizes the key steps of the planning process. And it breaks it down into 4 main buckets. At a high level, EPE provided the types of programs they wanted to offer and the measures within those programs and their goals for each program. And then we took that information and did calculations and looked at historical data to calculate cost effectiveness based on those EPE inputs.
And from reading your testimony, did EPE give you also the budgets for each of the programs?
Yes.
And were those budgets that you were working to sort of on a very close dollar basis, or were they more in the idea, more neighborhood kind of budgets?
That answer may depend on a program level basis, but in general, they give me a budget and say, here's our estimated incentive budget. Please use this to calculate the UCT.
And does the company provide you with preliminary measure counts as well as measures that they'd like to use?
They tell me the measures they'd like to include, but they do not provide measure counts necessarily.
Are there some instances in which they give you that?
I may ask them a
I
question.
think she just answered that question. And I mean, I overruled, excuse me, I'll sustain my own objection. I really don't need repetitive, redundant interrogation. So let's not ask any question more than once.
So what data did Frontier contribute to the process, Ms. Martin? Did Frontier itself analyze the statewide evaluators M&V reports from the past?
That was 2 questions, Ms. Stevens.
Well, did Frontier analyze the M&V evaluator reports, or did?
We use the evaluator reports for certain inputs.
Did you use just the most recent evaluator report, the 2020 report, or the ones going back several years?
Can you please be more specific about which input you might be referring to?
Maybe you should tell me which inputs. I guess that there are which inputs come from the TRM, and which inputs come from the EPE special, the EPE specific M&V work.
That's a broad question. I can say that we did rely on the evaluator report for the free ridership values, and those were from the most recent evaluation report.
And did you go back to earlier reports for any of the in-depth analysis of programs that were not fully M&V'd, is that the word, in 2020?
I'm familiar with the previous evaluation reports, but I apologize. Without being more specific, I can't say for sure if I looked exactly at X for usage in the plan.
Did Frontier consult the New Mexico Technical Reference Manual, or TRM, for inputs, or did EPE provide TRM inputs for you?
We use the TRM directly.
And did Frontier on its own consult with or refer to other TRMs from other jurisdictions for some of the inputs?
Yes.
Did Frontier provide recommendations to EPE based on its experience with other programs, with other clients of yours?
In general, if asked, we may have provided a recommendation on certain inputs, but
How about in this case? I guess the question is, were you asked?
this is a very long planning process. So yes, at points during the planning process, EPE asked for our recommendations on certain things and we provided it to them.
Ms. Martin, did Frontier make recommendations on incentive levels, customer incentive levels?
For most of the programs included in the plan, the incentive levels noted in my program forecasting assumption tables are based on actual data from the 2020 program year. So they're averages. We do not include final incentive rates in this plan. So we did not recommend any specific incentive rates.
When you say that you do not provide final incentive rates, does that mean that the incentives that are shown in all the little tables in ADM1 are not what the company is proposing to offer to customers?
They are averages. For most programs, they're averages based on actual participation. And it's our understanding working with EPE that they expect the rebate levels to remain about the same as they have in the current or in the previous program years, 2020 and 2021. And because of that, we feel comfortable using these averages as projected average incentive levels for each measure. It's my understanding that if EPE decides to drastically change any rebate levels, that they may work with implementers to verify measure level cost effectiveness.
Well, let me give you one example, which is the proposed new appliance recycling measures, I guess. That those call for, if I remember correctly, and lost her testimony again, those call for $50 rebates. Is that right?
That is correct.
And is that a firm commitment, or is that something that the company might change?
I'm not certain.
So
I apologize.
No, I apologize for interrupting you.
That's the value I was, that particular value I was given by EPE.
So, and I'm looking right now, just because it opened up to this, is a different example, residential comprehensive program forecasting assumptions on page 27 and 92. And there's some then we have, it happens to be recycling. I just got lucky, but very lucky. So here we have the recycling measures. We also have the heat pump water heater with a $300 incentive level. Is that right on this page?
Correct. And
you have some testimony in your rebuttal about that particular level of rebate. That's a new measure altogether, isn't it?
Yes,
Question is it a new measure or not? So please don't testify, Ms.
Yes.
Stevens.
Is that a new measure?
yes.
And in the last case, did EP and Frontier consider heat pump water heaters and not include them?
I don't recall.
So going to your rebuttal testimony, find the right page about. Your rebuttal testimony at. Let's see. Sorry, it opened it up to the. About this. I'm sorry, for my documents don't. Okay, now we're there. Your rebuttal to Mr. Brandt's testimony, Ms. Maybe we shouldn't take that back. Okay. I'm going to find this. I had it simple. It is actually. Oh, this is. Give me a second here. It was in your direct. That's what.
Okay, time's up.
I'm sorry.
Move along.
Okay, I'll go on to a different question. We'll get back to that one because it's interesting and it's in a different context. So based on your description of the process, Ms. Martin, did the process work differently when you were dealing with new programs, new measures within a program than they would be for existing measures?
I think that's a fair statement in some cases.
And did you do further analysis when a new measure was considered to be added?
If asked by EPE, yes.
If EPE had given you a new measure as part of their list of things that they like to include and didn't specifically ask you to evaluate it in any particular way, would you have had to go back to the company for more information, or would you have been able to do that, do an analysis with what you had in hand?
If the company requested to add a new measure to a program and they gave us the inputs, yes, that would be part of our calculations.
Next question.
And if they did not give you specific criteria or standards, would Frontier, based on their expertise in the field, would you have been the ones to generate the kind of assumptions and sort of parameters for a proposed new program? Or measure, pardon me, I need to be careful about wording.
This is EPE's plan and their goals. So we would work with them to understand their intention regarding a new measure. And if asked, we have the ability to provide inputs as needed. But I apologize. I'm not sure if you're asking about a specific input, but we can do the calculation. But during this planning process, EPE was asking us to evaluate the programs as they would like them designed. And so that's what we did.
Page, I think I have found where I had hoped to take you earlier. It's in ADM1. Everything is in ADM1, isn't it? ADM1, page 27.
We've already been looking at that one. That's table 18.
Yeah, yeah.
Correct? So we already
Right, we've
had
been
that
looking
up,
at
and you
that
asked her,
one,
and you asked her about the incentives listed for the heat pumps.
Right. And so if you could hang on to that and also look at page 5 to 6 of your direct testimony.
And then we're going to have to move on, Ms. Stevens, to concluding your cross-examination, please.
This is just, I want to ask Ms. Martin about this testimony. This is an example so heat pump water heaters are a new measure, correct?
Yes.
And on pages 5 to 6, you talk about a cost effectiveness test for the potential new measure and you see at page 6 that you use different incentive levels. Is that right?
Yes.
And those incentive levels were proposed by, was incentive levels proposed by EPE or requested by EPE for you to run the numbers on?
I believe so. I believe those numbers were recommended by EPE, but I can't say with certainty. We ran those very long ago.
Okay. And were those UCTs run on a standalone basis for the measures? The point, I
didn't really understand that question. Could you please restate it for my benefit?
To reach these UCT results, did you just run your test, your UCT program, as if there were just that particular measure, devoid of the rest of the residential comprehensive program?
Yes.
Thank you. On page 52 of the report, the ADM1,
Question?
yeah, you state that online that let's see, this is the Energy Saver program, and you state that, looking for the line, it doesn't have line numbers, so it's a little hard to find. You state that you indicate that EPE may offer EPE plans to potentially offer solar attic fans and window air conditioning as new measures. What does potentially offer mean in your understanding of how the programs will work in practice?
It means they may include those two measures in their program offering.
But again, by putting it in here and putting that in your table of forecasting assumptions, you're not asserting that that's going to be part of the program when it actually goes into operation?
EPE asked us to include those as potential measures for the purpose of calculating cost effectiveness.
Potential measures. Okay. I think I've just got done. I just wanted to ask you about the residential lighting program, and that's in your rebuttal at page 7.
Okay.
Question.
Yeah.
I asked that because all the 10 seconds and 8 seconds, they add up to
Okay.
minutes, and minutes make hours. And if we can keep the seconds under control, we can keep the minutes under control.
The residential lighting section begins on page 7 of your rebuttal testimony, right, Ms. Martin?
Yes.
And I'd like you to just focus on, I'm not going to spend time reading it aloud. Just focus on the question, not the answer, but the question from lines 15 to 18.
Okay.
Is it your understanding that Ms. LaRock recommends terminating the Energy Saver LED lighting measures?
It was my understanding she was suggesting the removal of LED lighting measures from all residential programs.
And did you read her testimony before you filed did you read her entire testimony before you filed your rebuttal, or did you read excerpts?
I read her entire testimony.
Okay. Could you turn to her testimony, which is CLC Exhibit 1? It hasn't been entered into evidence yet, but I think we can do this. And I think that what you cited in that question, that question was page 30 of Ms. LaRock's testimony. Can you get
It's 4 through 11. It says it right there.
Right.
So we don't have to say what it already says.
Right. So would you go to page 30, please, of Ms. LaRock's testimony?
Okay.
Okay. And I believe you were referring to the question and answer, I think, on lines 8 through 12. And did you notice that the answer says generally LED lighting measures should be removed from EPE's energy efficiency programs?
Yes, I see the word generally.
And if you would go down to, since you read the whole testimony, if you would go down to page 35 of Ms. LaRock's testimony, this is specifically the question beginning on line 6 is, what is the city's position on the inclusion of LED lighting measures in the 2 low-income programs? And do you recall this response, Ms. Martin?
Yes.
You did not provide any rebuttal testimony concerning the city's recommendation that there be a billing comparison done for low-income customers before LED lighting measures are removed from the Energy Saver or Energy Smart programs. Did you?
I don't have a question about that in my rebuttal testimony.
You do have a question about that?
I do not.
Okay. Are you in a position to state whether the company is amenable to that sort of an analysis before phasing out LEDs for low-income customers?
No.
Thank you. That's all my questions.
Thank you, Ms. Stevens, very kind, and thank you very much for keeping it relatively short. We appreciate that. So let's move on to the next party's cross-examination. Is there anybody who chooses to go next? I'll give you guys the option. Ms. Lynch, please do so.
Good morning, Ms. Martin. My name is Kara Lynch, and I'm the attorney for CCAE. It's nice to meet you.
You too.
Thanks for being here. Could you please turn to page 10 of your rebuttal testimony and just let me know when you get there?
Okay, I'm there.
Okay. And on page 10, you address the proposed incentives for heat pumps and heat pump water heaters, correct?
Yes.
Okay. At lines 9 through 11, and I'm going to paraphrase this, you state, while these are reasonable potential incentives, they are not intended to represent the final incentive rate EPE may offer. Is that correct?
Yes.
What does that mean, that they are not intended to represent the final incentive rate?
It just means I can't say with certainty that EPE's exact rebate levels for these measures will match those we assumed.
Okay. So I'm just wondering, when will customers or stakeholders be informed of the final incentive rate for heat pumps?
That will be up to EPE. My expectation is that will be up to EPE.
Okay. And you agree that heat pumps, specifically heat pump water heaters, are relatively new technology on the market, correct?
I think that's a fair statement.
Okay. And do you also agree that within the context of the entire EELM plan, the plan we are examining here, specific programs such as the heat pump program do not need to be, quote, cost effective? Under the EUEA?
EPE is not proposing a heat pump program, so I apologize if I'm confused. It is EPE's position that the portfolio of programs need to be cost effective. I'm sorry.
So the portfolio is separate from each independent category of program proposals.
The portfolio cost effectiveness is a sum of each program's cost effectiveness.
And that's what the commission considers, correct?
That's my understanding of EPE's position on the matter.
Okay, fantastic. So to increase uptake of heat pumps or heat pump water heaters, do you agree that higher incentives could lead to greater uptake by customers?
In general, yes.
However, here the incentive EPE is proposing, do you agree that it adequately or reasonably incentivizes customers to purchase heat pumps over other technologies that exist for either air conditioning or heating air or heating water?
Every customer is different, so that's difficult to say for sure. I did not consider it to be an unreasonable rebate level for that measure. considering the cost effectiveness restraints for the program.
Okay, so how does EPE consider the incentives for, newer technology being introduced to the market?
I'm sorry, I'm not sure if I understand the question exactly.
Does EPE give extra weight to technology such as heat pumps when it considers the incentives it sets for that newer technology?
I don't want to speak directly for EPE. I can say in general that is a consideration.
Okay, so while EPE has proposed an incentive rate, it may still change that incentive rate dependent upon the evaluation. And so customers could possibly be incentivized at a higher rate to purchase heat pumps, correct?
Correct.
Okay, fantastic. Thank you. Those are all of my questions, hearing examiner, and it was nice to exchange with you, Ms. Martin.
Thank you.
Thank you, Ms. Lynch. Mr. Black, would you care to cross-examine?
Thank you, Mr. Hearing Examiner. Staff has no questions of this witness, and thanks Ms. Martin for her time and efforts.
Thank you, Mr. Black. Mr. Simpson, I didn't intentionally mean that you would be last, but you're last, but certainly not least if you'd like to cross-examine.
Thank you. I do have several questions for Ms. Martin.
Please.
Good morning, Ms. Martin. I am Phil Simpson. I'm a pro se intervener living in Las Cruces. And I do have some questions, and they're primarily in the area of heat pumps and heat pump water heaters that we've just been discussing. So were you listening yesterday to Ms. Pereira's testimony?
Yes.
And so can I refer you to EPE Exhibit 1, her direct testimony, page 32?
You said her direct?
Yes.
Okay.
Her direct testimony, page 32, line 17 to 20. Did you, and this is line 17 to 20 to paraphrase, is talking about adding additional measures to the low income program, air source heat pumps and heat pump water heaters. Did you hear her or recall her saying something about something like those measures were inadvertently left out of the program?
I do remember her saying that.
So are those measures that may be added to the Energy Smart and Energy Saver programs?
It's my understanding that heat pumps and heat pump water heaters will not be included in the Energy Saver program.
Might they be included in the Energy Smart program?
I believe so. I believe there is some form of heat pump measure assumed in that Energy Smart program.
Okay, can we look at your direct testimony 80M1, page 54?
Okay.
So that's Energy Saver.
Correct.
So I guess Energy Smart next, I think. I forget which one's first. Yeah, Energy Smart's next. So let's look at table 54 on page 61. And are there any heat pumps or heat pump water heater measures on these tables?
Not in tables 54 or 55.
Right, and I guess that goes all the way to 57. In particular, table 56.
Apologies.
So my question is, do you see any heat pump programs there? And if so, can you elaborate on what those consist of?
In table 56, there's a measure noted as heat pump replacing portable electric.
Okay. So I assume that applies, that's talking about portable electric resistance heaters.
That's my understanding. For this program, the implementer provided their own analysis of which measures, savings, and rebates they would offer. So I wasn't as directly involved in this particular program.
Do you think that measure might be extended or expanded to include homes that might have permanently installed electric resistance heating?
I'm not sure.
Does that seem like a reasonable measure to include? Given the efficiency levels of heat pump versus resistance heating?
It could be.
Okay, thank you. Let's, I want to refer you back to Ms. Pereira's testimony, again, page 32. And it's sort of the next section, page 32, line 21 through line 2 on page 33. And this is talking about the residential comprehensive program. And I want to look or explore the UCT calculations a little bit more. First, I guess do you see the Ms. Pereira's testimony from line 21 to line 2?
Yes.
So it's talking about cost effectiveness of UCT calculations, correct?
Correct.
So and now, can you read this last sentence that begins on page 22 and goes on to page 2? Can you read that aloud for me, please?
This incentive has been modified as much as possible while still complying with the cost-effective UCT considerations.
Okay, thank you. So I want to go back to your rebuttal testimony, page 11.
What is the question, sir?
I apologize. I have a erroneous reference, so that we will move on in the interest of saving time.
Okay, strike the question next.
Next question. Let's go to table 17 in ADM 1. This is on page 26 of ADM 1. And so the question is, I'm looking at table 17. The last two columns are for air conditioning and heat pump. And I'm looking at the annual kilowatt hour savings. And you can see there, would you say they're significantly higher for heat pump than for AC?
Yes,
And those are both per, this annual kilowatt hour savings is per participant, correct?
correct. It's an average based on actual 2020 projects.
Okay, but it's an average per participant?
Correct.
And it's the same for the incentive levels and dollar amounts. Those are average per participant.
Yes,
So it would be reasonable to compare those values. For example, dividing annual kilowatt hours for heat pumps by the cost incentive for heat pumps, and the same calculations for air conditioning. That would give you sort of a kilowatt hour savings per dollar of incentive, correct?
correct. My only note on that would be, because they are averages and not weighted averages, you could have a handful of very high saving projects due to the installation of a heat pump in an all electric home that could skew the results a little bit, if that makes sense. But to your point, yes, you are correct.
Okay, but so I understand that these are averages and there's a lot of variation by individual participant, but does this line of reasoning suggest that heat pump incentives are more than 4 times more cost effective than air conditioning incentives?
Without running those exact measure level UCTs, I can't comment on that exact note.
I actually didn't understand your question, Mr. Simpson. It seemed like a simple question, but it was like, is this red apple more red than this yellow orange, or this orange? Because you were comparing the incentives for two different products. The question, frankly, didn't make sense to me. So am I missing that? Or did I incorrectly understand your question?
Well, Your Honor, I was comparing the annual savings relative to the incentive for each of those two measures. So I was trying to, and I thought I confirmed that I was not comparing apples to oranges, because I was, using a sort of dollars per kilowatt ratio.
Well,
for
an
each measure.
incentive, almost by definition, is to encourage the purchase of a product. And you ask whether whether at the incentives for heat pumps is 4 times more effective than the incentives for a different product. So that's comparing the incentive, whether the person is 4 times more likely to buy a heat pump rather than buy a electric water heater. Is that your question?
I think not exactly.
Okay, so I really didn't understand it. I like to understand the questions.
Well, so Your Honor, I'll back up a minute. And
Sure.
originally I had intended to walk through the calculations, but I thought I would avoid that in the interest of time.
Okay. Well, there seems to be a missing link in the chain to connect the front and the back, and it's taking the incentive and the purchasing more of them as a result of the incentive and then to the efficiency level. And we missed the efficiency link, it seems. I could be wrong, but I just didn't understand the question enough to get a useful answer to the question. And I thought you could clarify it for me, if you would.
Yes, sir. I will try. I was, I guess, not looking specifically at customer behavior, but I was looking at the effectiveness or efficiency of the incentives in terms of the incentive amount spent per kilowatt hour of savings.
You know, I think I understand. So there's the incentive has to create the purchase, and the purchase then results in an efficiency. It doesn't go directly from incentive to efficiency. And you're talking about the effectiveness of the dollar amounts of the incentive relating to efficiency for the two different products. So it's like a substitute, one or the other, and the efficiency of one or the other, and the incentive creating the purchase of one or the other, resulting in an efficiency of one or the other. That's a long way of explaining it, but I just I missed that. I believe I missed a central link in the chain you were pulling. Okay, anyhow, that's, I don't like when I don't understand the question, because then the answer doesn't provide me with any information. Would you care to comment on my query, Ms. Martin? Or maybe you wouldn't.
I don't typically look at the measures from that perspective, but I think I understand where Mr. Simpson's coming from.
Okay. All right. Well, I'm sorry to interrupt, Mr. Simpson. Could you just proceed with your cross-examination?
Yes. I guess let's move on to another part of the UCT calculation, or a part of the UCT calculation, because I guess this isn't specifically UCT. Let's go to EPE Exhibit 4, your rebuttal testimony, page 11. Line 17 to page 12, line 11. So
Okay.
it's the bottom of page 11 to the top of page 12. And it's talking about the free ridership assumption. So without reading this whole paragraph, but does this essentially say that you use the evergreen values for free ridership, which are given only at the program level, not measure level?
Correct. That's what we use.
Okay. So I want to go to the direct testimony of Justin Brandt in page 15, lines 1 to 6.
I'm sorry. Is this an exhibit? I'm sorry. Which exhibit am I looking at?
This is I'm looking at the direct testimony of Justin Brandt. It was CCAE's one and only exhibit.
Sorry, I'm going to the folder here.
Okay. Take your time.
I have a Simpson Exhibit 1, direct testimony of Philip Simpson, and a Simpson Exhibit 2, EPE response to first staff interrogatory.
It's not one of my exhibits.
Oh.
It's the direct testimony of Justin Brandt, that the witness for CCAE.
I
And
apologize. I apologize.
you're-
If I have that. I don't see it, but I'll try and answer the question.
Well, it was related to your rebuttal testimony. And this is regarding heat pumps specifically, and the free ridership value of 36.32%. You probably remember that value for the residential comprehensive program.
Yes.
Do you agree that free ridership value, specifically for heat pumps, may be overstated?
I'm not certain, but as a newer measure, it wouldn't surprise me if the evaluator decided to take a closer look at that in their next evaluation.
Okay. And so would you be willing to work to take his suggestion that El Paso Electric work with the independent evaluator to develop free ridership values specific to heat pumps as part of its evaluation process going forward?
Yes, if EPE asked us to help with that, we'd be happy to do so.
When might you be able to do that in terms of time frame?
That would be up to EPE.
If EPE asked you to do that in the next 6 months or so, could you do that?
Frontier's happy to work with the evaluator based on their schedule. In terms of how long it might take the evaluator to conduct that analysis, I'm not certain.
If the evaluator could conduct that analysis in 6 months, could Frontier support that?
Yes, I believe so, if EPE directed us to help with that.
Okay, thank you. So I want to move on to heat pump water heaters. And we're about 2/3 done with my questions, just as a point
Thank you,
of
Mr.
reference.
Simpson.
So I'm struggling a little bit because my question refers to Mr. Brandt's testimony, which you don't have. So let me try to think how we can
Well, if there's
handle.
particular language, you could read it into the record and ask her about it. You know, if there's
Okay.
a line or a paragraph or something like that in his testimony, that's not unusual to do that. And his testimony is pretty
Okay.
short, so can't be that long.
Sure. So I will. I'm referring to the direct testimony of Justin Brandt,
Mhm.
and it's addressing the free ridership value.
What page?
So it starts on at the top of page 13 regarding proposed incentives for heat pump water heaters. And the section I want to read to you is at the top of page 14. It says, similarly, the assumption around free ridership contained in the DSM plan for heat pump water heaters is unreasonable. According to data from the Energy Star program, heat pump water heaters had a market share of 2% nationally in 2020. These sales are concentrated in a few states that are providing significant support for HPWHs. So the market share in New Mexico is likely to be much lower. Given this low market share, I recommend a free ridership assumption of 0 for heat pump water heaters. Do you have any, so that's the end of the quote, but do you have any reason to doubt Mr. Brandt's testimony in this regard? That heat pump water heater free ridership in New Mexico is likely much less than 2%?
I don't have any information that makes me doubt his statements. I can't confirm it either, but I have no direct reason to doubt that.
Okay, so I think I asked you a similar question regarding heat pumps, but specifically regarding heat pump water heaters, where we have a more specific recommended value from Mr. Brandt. Would you and our well, I'll ask this and you can probably, I can guess your answer. Is El Paso Electric opposed to using a 0 or 1% free ridership value specific to heat pump water heaters rather than the general 36.32% value used for residential comprehensive?
EPE will assume the free ridership value suggested by the evaluator. I do not see them objecting to a 0% free ridership value.
Do you
if it were
believe,
suggested by the evaluator?
if it were suggested by the evaluator?
Correct.
Do you think there's an opportunity to work with the evaluator to come up with a different, potentially much lower free ridership value?
Yes, if the evaluator is open to it, I think it could be something to work together on.
Okay, so how difficult would it be for Frontier to calculate the maximum heat pump water heater incentives that would still result in a UCT greater than 1? You know, for example, if using a free ridership value of 0.
If EPE asked us to do that calculation, it would be fairly straightforward.
Thank you. Switching gears just a little bit, since El Paso Electric has argued that each individual measure doesn't have to meet the UCT standard, could the heat pump water heater incentive be raised to $1,000 without violating the program or portfolio standards?
Without running those calculations, I can't say for sure.
With those so on a portfolio basis, given the small number of heat pump water heaters that we're talking about, could you confirm that not on a program but on a portfolio basis, it would be fairly difficult to exceed the UCT value just by adding $1,000 as an incentive for heat pump water heaters?
Again, without doing the calculation, I don't want to say for sure, but in general, on a portfolio-wide basis, if the heat pump water heater incentive were increased and there were only a very few number of units actually installed, I would project that the overall portfolio would remain cost effective.
Okay.
But that's a lot of assumptions there, but right.
Thank you. Thank you for your testimony. I appreciate it. And that is all the questions I have.
Thank you, Mr. Simpson. I believe there's no further cross-examination. Am I correct? No other. All right. So Ms. Olson, if you would like to do some really short redirect to clarify some subject within the cross-examination, you're certainly welcome to do so.
Thank you, hearing examiner. I just want to check real quick. We've been going for an hour and a half. I want to be respectful of the court reporter and everybody.
Thank you. So you want to take a break before you redirect? Is that your point?
I'm available for either. I'm just taking a quick look. I'm not sure that I actually have any redirect. I can combine that into a break, or I can just take a second to look through my notes. It's up to you.
Let's combine it into a 5-minute break. Thank you. It's now 11:31. We'll be back at 11:36. Thank you.
Yeah.
Hi, everyone. It's 11:36. The 5-minute break is completed, so let's continue. Oh, where is Miss Olson? Hi, Miss Olson.
I'm back, sorry.
Wonderful. So let's continue with your, well, if you'd like to rehabilitate the witness within the scope of the cross-examination, you're welcome to ask some questions.
Thank you, hearing examiner. In order to move things along, I've reviewed and I don't have any redirect.
Thank
So
you. That's wonderful.
thank you.
So there will be absolutely no recross because there was no redirect. Can we, Miss Martin, you're welcome to stay on, or Miss Olson, I'd like to just release her from the hearing. Is that okay? Thank
Yes,
you.
I'm sure she would as well.
Thank you, Miss Martin. Thanks for being here. Take care. Have a great day.
Thank you, you too.
All right. And I understand you have Mr. Hernandez ready to testify, Miss Olson?
I believe that's correct. Let me scroll through my gallery here to see if I see him.
Yes, I'm here.
There he is.
Can we swear in Mr. Hernandez, Mr. Lee?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending shall be the truth, the whole truth, nothing but the truth?
Yes, I do.
Please, Miss Olson.
Good morning, Mr. Hernandez.
Good
Will
morning.
you please state and spell your name for the record?
Sure. Adrian Hernandez, ADRIANHERNANDEZ.
And Mr. Hernandez, what is your current position with EPE?
I'm a senior rate analyst.
And do you have before you what has previously been marked as, so make sure the exhibit right, EPE exhibit number 5?
Yes,
And do you recognize that document as the pre-filed direct testimony that you submitted in this case?
yes,
And was that direct testimony drafted by you or under your supervision?
yes,
And does that direct testimony incorporate the corrections to your exhibits included with that testimony that were identified in EPE's July 30th notice of errata?
yes, this version does include the errata.
And do you have any additional corrections to your testimony, to your direct testimony or exhibits?
Yes, I do.
Can you please walk us through those corrections?
Sure. On page 8, line 11, it says treatment does lend itself to carrying charges. It should say does not lend itself.
And just to clarify, these are corrections that you identified today. They're not pre-marked on the exhibits we circulated.
That is correct. Yes, I apologize for that.
Okay, and do you have any other corrections?
I do have one more that came about yesterday when Ms. Perea made a correction on her exhibits. Those footnotes that she added to her exhibits. On my exhibit AH5, page 1, line 8, on the far right side where it says reference, it says annual report. I'd like to change that to, I'd like to strike that and replace it with exhibit AGP2.
Okay, and do you have any additional corrections?
No, that's it.
With those corrections, is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes,
And if you were asked these same questions today, would your answers be the same under oath?
yes,
Mr. Hearing Examiner, El Paso Electric offers EPE Exhibit number 5, along with accompanying exhibits with the changes noted by Mr. Hernandez on the stand this morning.
Thank you. Let's see if there are any objections. Mr. Simpson, any objection?
No objection, Your Honor.
Thank you, Mr. Black.
No objection, Your Honor.
Ms. Lynch,
No objection.
Ms. Stevens? Okay, so she's not back from our 5-minute break, so I'm not going to, she's just not going to have an opportunity to cross-examine or, Ms. Stevens, are you there?
I am. I just forgot to, whoops. I'm trying to start the video here. I've been here all along.
Oh, wow,
So
nice.
I apologize. I was looking at his notes. Mr.
Any objection?
I picked up that knot. I'm glad that I don't have to ask him for it. Thank you, Mr. Hernandez.
All right, there being no objection, this exhibit, which is labeled, what is it labeled, number 5?
That's correct.
I have to get to the first page, go back to the first page. EPA exhibit number 5, there being no objection, is admitted into the record. It's direct testimony of Adrian Hernandez on behalf of El Paso Electric Company dated July 15, 2021. Let's move on to cross-examination.
Sorry, we still have to.
Oh, rebuttal. Yeah, the rebuttal. I'm sorry, I made that mistake now 3 times, and I'll try not to do it again.
This is the last one, so.
Okay.
Mr. Hernandez, do you have before you what's previously been marked as EPE Exhibit number 6?
yes, I do.
And do you recognize that document as your pre-filed rebuttal testimony?
Yes,
And was this rebuttal testimony prepared by you or under your supervision?
yes, it was.
And do you have any corrections to your rebuttal testimony?
No, I don't.
And is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes,
And if you were asked these same questions today, would you give the same answers under oath?
yes, I would.
Mr. Hearing Examiner, El Paso Electric offers EPE Exhibit number 6, the rebuttal testimony of Mr. Hernandez.
All right, once again, we'll go around and see if there are any objections. Ms. Stevens, any objection?
No objections.
Ms. Lynch?
No objection. Thank you.
You're welcome. Mr. Simpson
No objection, Your Honor.
and Mr. Black? Hi, Mr. Black. Any objection to the admissibility of, to the admission, excuse me, of Mr. Hernandez's rebuttal testimony?
No objection, Your Honor.
Okay, well, that's wonderful because I don't have to decide anything. Everybody agrees that there's no objection, and EPA Exhibit number 6 is then thereby admitted into the record as evidence.
And Mr. Hearing Examiner, we tender Mr. Hernandez for cross-examination.
Thanks a lot. Boy, I don't know which order we should go. And Ms. Stevens, we've taken you first for the few times, and I had a reason for doing that. Do you want to go first again?
Whatever. I just have really a few questions for Mr. Hernandez.
Okay.
But if somebody else would like to go first, I'd be delighted to not.
I don't have a particular order, but you have to do. Mr. Black, you nodded your head. Do you want to go first this time?
Actually, the staff has no questions of Mr. Hernandez and it appreciates his participation in this proceeding.
I hope you would do that. And it's like a perfect example of how we can get through this case today. So with that example, let's move on to Ms. Stevens. You have some brief questions.
Yeah. So good morning, Mr. Hernandez. How are you today?
Good morning. Good.
I have a couple of little questions about your direct testimony, and then the rest of my questions are all about Exhibit AH3 and the proposed collection of the $901,000. So if we could just do a little housekeeping, I guess, here. Your direct testimony at page 10. page 10, lines 15 to 17, you talk about that $75,000 customer cap, and you say that it could happen. Has EPE historically had customers that were limited by that cap?
Not recently. Yeah, not since I've been involved with these proceedings. We haven't had that happen. It's been
So would you
close,
say that
but it
is your
hasn't happened.
testimony sort of just covering the bases, or is it in anticipation of?
The only reason for that is because of fuel prices. They've been relatively low these last few years. And
Gotcha.
so just to, make sure that we cover our bases and we check back and make sure that it doesn't exceed it.
Yeah, that's a very good point. Could you turn to page 12 of your testimony? And in the middle of that page, you've got some numbers about the rate impact of the proposed EUREF. And I understand that the total charge will be a little less under your agreement in the rebuttal testimony to use a 2-year reconciliation, but just wanted to ask you whether you agree that as originally proposed, the increase in the EUREF factor would be a 50% increase over the existing factor.
Total?
From 124 to 245 per month for the average residential customer?
Yeah, the original proposed?
Yeah, the original proposed.
Yeah. I think, well, what I say in my testimony right here on line 11 at the end, I say it's a 1.5% increase relative to the total current bill.
Relative to the total?
To the total current bill.
Thank you.
No problem.
And in terms of the EUREF factor itself, would that be approximately a 50% increase?
I suppose you can say that. I haven't actually looked at it that way. I normally look at the bill impact, to customers.
As far as the bill impact, you just mentioned about the fuel prices going up. The EUREF is collected as a percentage of most of the elements on the
It's a
bill.
percentage of the customer's bill, and it includes both the base revenues and fuel revenues.
So if fuel costs are going up, unfortunately, the EUREF collections will increase.
Yeah,
without increasing the EUREF factor, you could see an increase in the EUREF revenues. Is that right?
If the total bill goes up, then yes, the percentage of the bill charged will increase.
Thank you.
Thanks.
So turning to your rebuttal testimony and the agreement that the company has made to recovering the reconciliation, cutting the reconciliation amount in 1 year, for 1 year by half, to essentially you're proposing to collect that over 2 years. Is that right?
Could you repeat the first part? Did you want me to?
That 900,000 reconciliation amount.
Yes.
In your rebuttal testimony, you're essentially agreeing to cut the factor in half and spread it over 2 years. Is that right?
Yes, that's correct. Well, I'm the first part is correct.
Okay. So explain to me, because I don't think it's in your testimony, how the company would handle ending that factor or reconciling that reconciliation.
Yeah, the process will be the same as what we did in this filing. After when we are going to the next filing, whatever years have passed, we would then have calculated a cumulative overage or underage, and then we would apply the same type of treatment to the factor.
Well, maybe I'm a little confused by your testimony, I think it's I thought that the reconciliation amount was developed as a standalone sort of factor. It just gets rolled in to here it is. It's the errata version, your current testimony, direct exhibit AH5, page 1 of 3. And I'm looking at those EUREF components, the last lines 12 through 16.
Yes, I'm there.
So, okay. So explain to me whether it's the company's intention, and this was the direct. Is there a revised version of this in your rebuttal? I don't think so.
Yes, there is.
There is. Let's go to your rebuttal then. So, okay, yeah, this is exhibit AH1R in your rebuttal, page 1 of 3. And this is good. Okay. So now we've got the, so line 17 here would be the amount of the factor that you're going to, is line 17 here the amount of the total EUREF factor that's associated with collecting that $900,000 historic over expenditure overage?
The cumulative overage, yes.
Right. And the point that says 0.2859%, that's designed now to collect $900,000 over 2 years, right?
It's still going to be in effect for 3 years. It's just been cut in half.
And if it's going to be in effect for 3 years, won't that mean that you'll collect $1.35 million, because it's designed to collect roughly $450,000 a year?
Not necessarily. We'd have to look at it year to year. I think typically what ends up happening is we'll see and by the way, let me add something here. The whole reason why we request this reconciliation, so even if that does happen, we'd have the ability then to return that money to the customers, where in the past we haven't had a chance to do that. The reason why I agreed to answer your question, the reason why I agreed to 2 years is that my initial proposal was based on the calculation here, which is using revenues for 1 year. And when staff in their testimony made the argument that it should be cut in half because it's going to apply for multiple years, and because my calculation, and they were correct, is based on a 1 year's worth of revenue, it made sense. And so I agreed to what staff had, what their position was. So that's why I agreed to cut it in half. Either way, it'll get reconciled.
Mr. Hernandez, as you know, the city didn't support this at all, but so I'd like to, assuming that there is going to be a $900,000 adjustment, wouldn't it, given the 3-year span between proceedings, wouldn't it make more sense to have divided it over 3 years so that you'd be close?
It's possible, but I feel like, excuse me, I feel like over 2 years would give us the information we need by the time we have our next proceeding to see if we've already collected that. And I think the other thing I want to add about this is that we don't know what the result's going to be, right? This is just a presentation of what we think it'll be. Depending on how expenditures turn out and collections turn out, I can't predict what the underage or overage will be in these next few years. So, so basically, this is an estimate.
So will you be reconciling that is it your intention for the line 17 factor, the 0.2859%? Will you be tracking that and reconciling it on a month-to-month basis as like a separate component of the we know what the dollar amount is, right? The 900,000, but will you be reconciling it on a month-to-month basis based on 0.2859% of the revenues? And I guess I could ask you to look at your
If I
direct
could answer your
testimony.
question really quickly.
Will you be
Yes.
reconciling, will you be tracking that
Yeah.
in your reconciliations as a separate component?
Not necessarily.
Now, if we could turn to your direct testimony, and I have too many things open here. As that, wait. AH3 I'm looking for. Yeah. AH3, page 2 of 5. And
Did you say page 3 or?
Page 2 of 5, AH3, it's page
AH3,
23 of the PDF, if you're looking at that.
I'm pretty lost now. Are we on page 3 of the direct testimony?
We're on exhibit AH3 in the direct testimony.
I
It's
see.
page 2 of 5 of AH3. It's page 23 on the PDF, Mr. Lennon, but I know you've got things on paper as well as.
I got a combination at this point, but
Yeah.
AH3, right?
Yeah, it's the page with all the tiny numbers.
We love those.
Yeah, it's easy to spot because it's like the densest page in probably anybody's testimony.
We wear 3 pairs of glasses so that we can see those.
Do you
Yes,
have those like blue ones for looking at your computer?
those are, yes, they are, exactly.
Are they good?
Well, not because they're blue, but because of the right prescription for 18 and a half inches from my eyes.
Really? Oh, wow.
So, and you know, whether you leave that on the record or not, Mr. Lee, is your prerogative. I don't care if it remains.
I'll ask you about that when we go off the record.
Exactly.
So have you found it yet, Mr. Lennon?
Yes, ma'am.
Me too.
I know that Mr. Hernandez has. I'm not sure, Mr. Lennon, are you with me? Great. Okay. So for example, in the future, I understand that the intent of I think that the intent of collecting the 902,000 at the very lowest corner there is so that you can start another reconciliation similar to this with a 0 starting point. That's the goal, right?
Well, actually, the beginning balance is 902,000.
Oh, yeah. Okay, right. See, so will you be reconciling just that 902,000 and doing it on a monthly basis based on that factor of 0.2859% in like a separate column in this type of a reconciliation, or will it all get merged into one big pot of money?
It's all merged into what we see here on this exhibit. Every single one of these columns is what contributes to that 902,000. So I couldn't separate it out. I mean, it's part of the expenditures, right? I mean, it's not separate from that first number in my exhibit, my tariff exhibit, where we talk about the percentage of expenditures, except that the difference is that these are actuals instead of projected.
Well, at the risk of making everybody want to shoot me, except that I'm not in the same room, if we went back to, toggled back to your rebuttal exhibit, AH1R, where we have the EUERF components, you know, that total up to the 4.35% factor, will you will you be using the utility incentive factor of 0.2605% to generate the utility incentive column C on Exhibit H as you go forward?
Yes. So every single one of these elements of the tariff are also included in that AH3, H2. So all of them together is what make up that overage of 900,000.
Okay. Now I'm thinking, let's not talk about historically. I'm trying to figure out prospectively how you would do that so that we would know that you don't over collect the 900,000 figure. Because it seems to me that, well, I'm not going to testify. So when you did this table here on AH3, you used a factor for the expenses through base rates that was based on the 227,000 that was in the previous case. Is that right? Divided by 12, something like that? It's the same every month. So that was just prorated over 12 months?
Are we in Exhibit AH3?
We're in AH3 of your direct, yeah.
Let me go back. Okay, and then, I'm sorry, could you repeat your question?
Yeah, so when you if we look at the column that says administrative expenses through base, for 3 of those 4, well, for every year you use the same number every month, and for 3 of the 4 years you use the number 18,995,000. Is it correct that you developed that number by taking the whatever was 227,000, I think was the figure in Ms. Perea's first exhibit, and divided that just equally over 12 months? You didn't treat that, you did not, for this column, you did not treat that as a percentage of revenues. You treated it as just a flat dollar amount divided by 12?
Yes, that's correct. The internal admin cost is included to calculate the utility incentive in that 3rd column, but then it's immediately removed in column E because it's not recovered through the tariff. So that is correct. Those numbers right there are the internal admin costs.
And now the utility incentive column on AH3, that varies from month to month. Was that done as using a factor? Now I'm going to ask you to go switch back. Was that done using factors such as the line 15 of AH1R, is the utility incentive percentage, or was it done with a different calculation?
No, ma'am. So if we're still looking at AH3, these are all actuals that have been measured and verified. So once we know what that is, the final measurement and verification, then we know what incentive, the actual incentive that we can calculate on these actual expenditures. So then what this is it's a percentage of, let's say, I believe for 2020, it was 7.4%. So it'll be 7.4% times the expenditures.
Okay. Well, can you explain to me then, how did you get in January 2019, you have expenditures of 0 program expenditures, 18,995 of administrative through base is the 1,448 a multiplier of the 18,995?
Yes, ma'am. When I say expenditures, it includes both the program expenses that would be recovered through the tariff and the ones that are recovered through base rates.
I think I understand now. Thank you. Let's now turn to City of Las Cruces exhibit number 3, please. Have you got it?
Did you say exhibit number 3?
Exhibit number 3. It's labeled CLC Exhibit number 3, EPE Supplemental Responses to CLC 1-1, 1-31.
Yes.
And the 1-31 supplemental response, which begins on page 6 of 12 there, this would related to your testimony, and you are the sponsor and preparer of the supplemental response, are you not?
Yes.
Okay. And if we go to the supplemental response of CLC 131, attachment 1 on page 8 of 12 of the PDF.
Yes, I'm there.
This monthly summary, this is a monthly summary. Well, it's labeled Energy Efficiency Reconciliation from January 2021 to December 2021 as of December 31, 2021. Was this prepared in essentially the same fashion as Exhibit AH3?
Yeah, so I prepared exhibit AH3 using those annual reports that we've looked at earlier in the hearing. This exhibit here is prepared in a similar fashion, but only with the information that we have, up till now.
And looking at the little asterisk footnote, well, there are 2 footnotes. It's say December 20, the first one says December 2021 expenditures are not final, which is totally understandable since it was produced in early January. And then you have another asterisk for the final utility incentive is not known until savings are verified. And did you use the 2020 level of incentives in order to project incentives on this document?
No, ma'am. We used what we had at the time. And as you can see, it's 440,000, but it's definitely not anywhere indicative of what it normally is. If we go back to exhibit AH3, you would see that even in the last few years, the average is about 1.5 million. So we're not really showing the correct level at this point.
Yeah, and I think we're talking about 2 different things, Mr. Hernandez, because I was asking you specifically about just the methodology you use. We'll get to the number, but I just wanted to clarify because you got the footnote for the utilities incentive column. Did you since you says that you don't know what the savings are until verified, what special assumptions did you make? Because you didn't have the verified amounts, what assumptions did you make for that column?
That column, I believe it's using the base level incentive times the expenditures you see there. And I believe the base incentive there is still 7.1 since the 6.6 hasn't been approved yet in this case. However, it's no good. It's not useful, right? Since we don't have the right expenditures or the final expenditures,
right?
It's not a really useful amount.
I understand that. Now let's go. We're going to go back and forth, and I understand that particularly December is extremely incorrect. If we go back to AH3, we can see that the December numbers always are way higher. Is that right? For the program expenses column?
Yeah.
Way higher than the other months.
Way higher than the other months, that's right?
That's
and
correct.
Mr. Hernandez, is that because some of the program participants don't submit their requests for reimbursement till late in the year?
From what I understand, it is a very it's a different type of process. I mean, there's a lot of evaluating going on and inspecting, and there's a lot of back and forth. But since I'm not really the one that works in the energy efficiency department, I think that would have been a question that's better suited for Ms. Perea, but I do understand that there is a different type of process where it's not something that's invoiced and you pay it, in 60 to 90 days or something like that. I think it is a more time consuming type of process.
I just want, maybe I can just, since you don't do it internally, I just ask you whether this is a trend that you acknowledge you've seen year to year.
Yes, ma'am. And if I could add, I believe it's actually important to look at each year, of course, when it's final, but it really doesn't help to look at it month to month. I would say you need to take each year as a whole to really understand what happened in that year. Well, let's just, since you've highlighted December as being the most uncertain month, why don't we just, do you have a calculator? I apologize.
Can you find a calculator?
I didn't bring my phone. I'll see if I can use the computer. If you need me to, I could use Excel.
Yeah, I just want to do very, very, very simple. There's some very, very simple arithmetic here. And I would ask you to, because we know that the costs for December 2021 are inaccurate. If you could do the actual, add the December 2019 revenue expenses of $1,675,350.
And I apologize. I'm going to have to ask you to repeat that because I'm trying to open up Excel.
Are you trying to?
This is in my computer. So, all right. Okay.
Okay. So
My eyes are beginning to glaze over. What are we doing? We're adding the previous year, substituting it instead of the proposed.
We're going to try to get a historical average for the December expenses by using December 2019, the average of December 2019, December 2020. That's all. Very simple.
I understand that. And he already testified that the monthly figure is not useful. And I thought he inferred that the year, that means that we should look at it on an annual basis to have a useful number. Of course, we need the monthly to get to the annual.
Well, he also highlighted that was the month that was most often. If you just eyeball it, you'll see that is December is the month that's most
Always
off.
high, according to your words, always high.
Oh, always high?
That's what I wrote down here. December is always high.
Always high. Yeah, always high relative to the other months. But Mr. Hernandez also testified, or actually his actual exhibit in the discovery response has the footnote showing that December 2021 expenditures are not final.
My point is absolute figures, the actual numbers are not that important to me, except when the absolute number is important. And I really don't see why the absolute number is important in this exhibit right here.
Well, let me, if you allow me to continue,
I will.
It will become somewhat apparent, I hope.
I hope so too. Please continue.
So Mr. Hernandez, if we could, now that you've got your program set up, if you could add the December 2019 figure of $1,675,350 with the December 2020 figure of $1,586,459. And divide that by 2 to get the average for those 2 years.
The mean.
The mean. Does it mean the same as average?
Average is a more general number.
Oh, okay. I'm not a mathematician.
Okay, 1,675,350 plus 1,586,459 divided by 2.
Yeah.
Okay.
And the number is?
1630904.5.
Thank you. I'm glad I did it right. So now let's turn back, having that number in hand, let's turn back to the discovery response. And what's the difference between your that number, you'll have it, and the December program expense that has the asterisk for 2021?
So the 1.6 minus the 400,000
Right.
difference?
Yeah.
440.
So
440, 440, 680, 440, 648.
Yeah, so 1.2, let's just average out the difference.
Now, don't average it, just subtract, because we're trying to figure out how much more
Okay,
it would be if we used an average as opposed to what you've already built into your calculation here.
well, you could just include the 1.6 in there. And that would be typical of what we've seen the last 2 years, right?
Yeah,
So 1.6 million for December.
right, but I don't have the spreadsheet here, so we have to also remove the 440.684, or we'd be double counting. You know what I'm saying?
Yeah, so if we do
So-
that, you'd see that what we're currently showing as an over collection would actually be an under collection, right?
Right. And would you tell if you've done that arithmetic, if you want to do it by steps?
I
or
mean,
if
I'm
you
just doing
want-
it high level, just looking at the spreadsheet.
Yeah, okay, why don't we actually do the arithmetic? And you were subtracting the 440,684 from
Don't
the
subtract, just
average,
Put 1.6 million in there.
the 1.6 million, yeah,
1.6 million is what we would expect in December based on the average for the last 2
Right.
years. And then you add the 17,663 times the utility incentive, right?
I'm sorry, then you add the,
Sorry, the 17,663, which is the administrative.
well, excuse me,
expenses and base rates.
Mr. Hernandez, so again, I don't have a active spreadsheet here. When you replaced the 440,000 of program expenses with the 1.6 million of program expenses, have you removed that 440 in the calculation? It's not a spreadsheet, that's why I'm asking.
No,
you,
just replace it. Yeah, just replace or add 1.2 million if you prefer.
Okay,
Yeah.
that works. So
Awesome.
let's talk about, let's do this in round numbers. So we'll add 1.2 million, and you're saying that we should also add 7.1% on the 1.6 million? Is that what you're saying in the utility incentive column?
Yeah, so column A and column B should be added together and then multiplied times times 7.1%, which is what is included in here.
Mm-hmm. And can you do that arithmetic for me?
No, but we can talk it through.
Well, or can you? We would have to again use that as a substitution for the 32,000 that's in here, correct?
I mean, honestly, all we have to look at is if we have 1.6 million, just add that to that final cumulative balance. And that's still understating it, by the way. But it would be about a $600,000 under collection at the end of it. We don't have to go through every single column.
Thank you.
I'm happy to provide this to you in Excel if you want, but we can work it through.
No,
just
I'm
by
asking
looking at it.
you whether the 1.6, the 440,000 would be, then you said it would be a 1.2 million increment, right? Because we've already got
Additional.
440.
I understand the computations, Ms. Stevens, and I
Okay.
understand there's the whole thing you're trying to do. But why are you presenting this evidence? Please proffer that to me, because I really don't see it.
Mr. Hernandez, actually, given what we've looked at here,
Right.
where and the fact that through this year, this current year, the over collection there's a cumulative over collection.
Mhm.
If we're trying to adjust for the reality of the end of the year, is it appropriate if it comes to something much closer to zero or a couple $100,000, is it appropriate for the company to be asking to recover essentially $450,000 for 3 years when there really isn't an over collection anymore?
Okay, I think that was the answer to my question rather than a question for him.
That is, I asked him, is it appropriate, Mr. Hernandez, to do that?
Well, I was waiting for the answer to my question, and I asked for a proffer of why you're presenting this
Oh, I'm
evidence.
sorry.
So
Does
I'll
that
try
don't
to keep track of things. Is it your implication that the $440,000 figure estimated for December was incorrectly estimated because it should have been closer to 1.6 million?
Yes, I
Okay.
think we're in agreement on that, Mr. Hernandez.
Well, I didn't know that we're in agreement on it at all because the $440 is the figure that they used.
I'm trying to help get a more realistic result here because it would be unfair to say that they're really at over collective 1 million when there's going to be 1.2 or so extra. I think.
Right. And the underlying basis for yours, looking at the historical data on AH3, where the December is always higher. I understood all that stuff, and we didn't have to go through all those computations. You just think their 440 estimate is too low. Is that right?
No, I think that their attempt to recover $900,000 is inappropriate because that number, as of going into the next cycle, the next EUREF, is not going to be $900,000, and because it's already been reconciled essentially.
Can I respond to that, please?
Yeah, but I'm sorry, I'm arguing with the hearing examiner, not.
Mr. Hearing Examiner, to respond to you first, that 440,000 is actuals. It's just what we had as of January, whatever date we provided this response.
Okay.
So that is actuals, and that's why we had to put an asterisk, because we're saying it's not final, but it is what we have for actuals up to that point.
Yeah.
If they had asked us to provide an estimate, I would have provided something closer to 1.6 million, except they asked us for actuals for the year 2021. Now,
thank you, Mr. Hernandez, appreciate that, yeah.
now to respond to you, what you're trying to get at, Ms. Stevens, is that, no, if this was 1.6 million in expenditures in December, this cumulative over recovery that we're showing here of 1 million would actually be under recovery. And so we'd actually be adding to that overage that we currently have.
But Mr. Hernandez, you would not be adding to that over recovery because didn't you start the top line here, January 2021? You see, it starts with a cumulative over under recovery. Couldn't I just physically paste this under the other? Please, if we were to physically.
I'm sorry, I'm not catching whoever is speaking.
Okay, we'll both take a pause.
So Ms. Olson, did you have a comment?
Yeah, Ms. Stevens is testifying and then asking Mr. Hernandez to respond to that. If she wants to know, does it start with a over under collection, she should ask that question and then questions based on that assumption, but I'm not sure that she's established that assumption.
So I'll ask the question differently. Mr. Hernandez, if we were to just physically paste this discovery response underneath AH3, wouldn't that show that the way you got from a 902,000 over collection as of December 31st, 2020 to a cumulative over collection of $512,496 in January 2021 was by reducing the 900,000 by the 389,505 monthly over collection for January 2021.
Yes, and if you follow that all the way through and assume 1.6 million in expenditures in December, it would come out to be an under collection.
Right.
It would add to the overage that the company has. This is
I
why
don't-
this doesn't present a good picture.
I understand that it would, Mr. Hernandez, explain to me why it would be additive to the 900,000 if this is a cumulative, exercise.
Yes, ma'am. So since we're talking about accumulating a balance, right? The beginning balance in this case would be that $900,000
Right,
under collected, right?
right.
And so then if we get through the whole year and assume December is final and it's at about an average of the last couple of years, which is 1.6 million, then it would, that 1 million that we're currently showing
Mhm.
would actually go the other way,
Right.
and it would actually be an under collection of another 400, 500,000. Assuming, this is ballparking.
So that
Well,
all
I
made
think-
sense to me. What is the point?
The point is, when you say another under collection, hasn't this cumulative column here, doesn't that reflect, because we started with the 902 at the top here, doesn't that reflect accumulating, including the 900,000? I don't understand how we could be adding the 900,000 plus accumulating here. Just explain that to me, Mr. Hernandez.
Wait, hearing examiner, Lennon, can I
Yes,
just,
ma'am.
since I'm having a hard time following this. Ms. Stevens, where are you saying the 902,000 cumulative or over it?
That's at the bottom.
Where is that reflected on the discovery response?
It's reflected implicitly, because if you look at the
But
900,
I'm just saying, is it explicitly stated on there? And I think the answer to that,
I tried to ask Mr. Hernandez to get to the January 2021 cumulative under collection amount of $512,496. Didn't Mr. Hernandez take the previous, the December 2020 902,000 amount and subtract from that the January 2021 monthly over collection of $389,505. Yes, Mr. Hernandez?
Yes, and that's why I was trying to explain to you. So if you follow it all the way down and we assume 1.6 million in expenditures, it would result in an overage, which means an under collection for the company.
Correct, yeah. But you keep saying that would be in addition to the 900,000. I think that
No,
the
that's the beginning
900,000 is already addressed, is it not?
Yeah, so that's the balance that you're starting off with.
Okay, so under those circumstances, you don't need to go and and separately collect the 900,000 if you had the more up-to-date starting point, correct?
No, I don't agree with that. I think we're gonna collect the 900,000, which is related to the last few years, and then we'll see where we are going forward. And if we do end up over collecting, if we have the ability to reconcile, we can return the money back to customers through the tariff.
Yeah, I thank you, Mr. Hernandez. I'm finished, and I appreciate your testimony.
You're
And I
welcome.
hope everybody gets a lunch break or something.
Well, could be nice. It's 12:32. Who else needs to cross-examine Mr. Hernandez? Ms. Lynch?
CCAE has no questions for Mr. Hernandez.
Thank you, ma'am. Mr. Simpson?
I also have no questions for Mr. Hernandez.
I didn't miss anybody, did I? Okay, well, thank you, Mr. Simpson. And then Mr. Hernandez can be released. I don't think he'll be needed later. Ms. Olson, he's your witness. Is that okay?
Mr. Hearing Examiner, I have no redirect, so yes, I will ask that he be excused.
Mr. Hernandez, you're excused. Thanks for being here.
Thank you, sir.
Okay, so it is 12:33. That concludes your testimony, doesn't it, Ms. Olson?
Yes, Mr. Hearing Examiner, that concludes our presentation of our case.
Well, that's a really nice, convenient place to take a break. I was thinking 1 or 1:30, but it's a really convenient place. Does everybody agree with me on that, or does anybody want to go another hour or so?
Mr. Hearing Examiner, I agree with you, and I would appreciate a lunch break at this point. I also, not to jump the gun, but I think you mentioned doing an expedited lunch, and I don't know that that's necessary. I don't anticipate having significant amount of cross-examination this afternoon. We can pull the other parties, but I'm not terribly concerned on timing unless other parties have substantial cross-examination for their witnesses.
Well, that's good to know that you don't anticipate substantial cross-examination. So are you suggesting that we take an hour rather than a half hour?
I am Hearing Examiner, but that's just my lone opinion. I defer to the group.
See, I can hear the things you don't even say, so I want you to be impressed by that. Does anybody disagree that we should take one full hour for lunch?
Be fine. That's good.
Ms. Stevens,
That's good.
1 hour is good?
I
Okay.
have to get out some rulemaking comments, so I'd really appreciate having an hour for lunch.
12:32 on my thing here, my phone. So let's reconvene at 12:32. We're now in recess. I mean, 1:32. We're now in
Thank you.
recess.
You're on the screen.
Oh, thank you.
Ms. Stevens, were you the one that asked me about the blue glasses?
Yeah, Mr. Lennon, are we still on YouTube?
I think we are, so we need to watch what we
I'll
say,
ask this
but
discreetly because I have been avoiding between just being busy and COVID. I haven't seen my eye doctor in a long time, and I spend my life in front of my computer.
yeah.
So I wear contact lenses, which I probably shouldn't, which is why my eyes are always bleary, right? So you have prescription blue ones for the.
Well, yeah. Well, the blue is just a frame, so I could pick any frame.
They're not the special blue lens. What are they for? What do you have for your computer work?
Well, the interesting thing is my wife is a pharmacist, and she's really good about looking at linear prescriptions of drugs and things like that. And it's also a similar type of thing for eyes. So if she knows one measurement, like, well, infinity is a measurement, and then there's a measurement for, say, 24 inches for the prescription, you can interpolate from that data what it would be for 36 inches and what it would be for 12 inches. So anyhow, because of that, I end up getting glasses for various distances from the various screens. And so one will work really good for one distance, but not work for, say, reading. So I have different ones. And there's another advantage to have all these. I don't know if you know this or not, but if you are looking at a certain distance, like your computer screen for time, it's pretty good to stop and look at it at infinity, distance. So a different distance. Well, what I'm getting at is if you change the prescription, even though you haven't changed the distance you're looking at, your eyes have to work differently. And so long as the eyes are working differently, they have less fatigue. And I have a problem with just fatigue. If I don't change glasses or if I'm looking at the same distance for a long period of time, which is, a big part of this job basically. So I keep the 3 glasses with 3 different scripts, and I switch not only so that I can see the screen better, because I can see the screen with all 3.
Better, you can see the scene better, yeah.
But I do it so that my eyes
Exercise kind of.
exactly exercise my eyes, so they think they're focusing at a different distance. So there's
And do you have that special glass for computer screens in all of the pairs or most of your pairs?
well, one of them. No,
Oh.
I have different. They're designed for different distances.
But they're not designed. I've been reading this stuff or seeing advertisements for the blue glass and protecting your eyes from the screen stuff.
No, I don't even know what that is. So
Yeah.
I don't. That's definitely not what these are. So I don't know what that is. I never heard of it. Blue glass.
Oh, well,
eyes.
I'm so close to blind that I have one contact lens. It's that my one eye is so bad.
Close.
One contact lens is for the reading distance.
Yeah.
The other contact lens is for the distances.
Yeah.
So I have like built-in bifocals, which
I'm familiar with
my
that.
brain is probably all screwed up, but I think that anyway.
No, I'm familiar with that. I was thinking about getting LASIK, and they told me that that's exactly what they would have to do for
That they
mine.
would do
So
for that.
extreme that they
Yeah.
could do one eye with one script and the other guy with the other script, and my brain would learn how to, to switch eventually. But I
Yeah, my
elected
brain
not to
learned
have
a long
that.
time ago. I don't think I can undo it because when I do put on ordinary glasses, like to fly overnight or something,
Uh-huh.
the walls sort of, the concave walls sort of start doing things to me.
Yeah.
I've actually almost tripped because things,
Right.
yeah.
I know. I know that feeling myself.
Yeah.
I know the feeling.
Yeah.
It's unfortunate, but it's the way life is. As I get older, there's these infirmities that kick in.
Mhm.
So anyhow, I don't know that we should burden the YouTube audience with any
with
more
our
of our
discussion of
personal
our
stuff.
aging eyes.
Yes, and I would note that we haven't discussed
I
the
will
merits
make
at
an
all.
appointment, and you have a different theory on it. I'll ask my doctor about my optometrist about that because that wasn't one I'd ever thought of.
Well,
Thanks.
sure, you're welcome. Thank you. Take
Bye.
care, and we'll see you in a little
Have
bit.
lunch. Enjoy your lunch.
Thank you.
Needs to be. It is though. Surprised that everybody isn't back because I'm pretty sure it's till. Oh, 1:32. Oh, I wish I'm like a maniac and I don't need to. Okay, now I can go to the bathroom. What? Oh.
Ms. Lynch, did we plan on you presenting your case next?
No, I think it was, let me pull up what we agreed to. It was Simpson, Brandt, and then Dunn. Oh, no, City of Las Cruces, Simpson, Brandt, and then Dunn.
I wrote that down somewhere and I can't figure out where I wrote it. City Las Cruces. Then who would you write?
Simpson,
Simpson,
Brandt,
Mr. Brandt, okay.
and then Dunn.
All right, thank you. I'm sorry I forgotten that order. Brandt is your guy, right?
Correct.
CCAE, and Mr. Dunn is with staff. Okay, so CLC will be next. Hi, Ms. Stevens, welcome back.
Hi, I see that Lisa's got a box there and she doesn't have her, Lisa?
Oh,
There she is.
I don't like
Yes.
people spying on me when I turn off my.
So you put like a sticky note on top of
No,
it?
I have a door.
Yeah, I have one too. I used to use these little long pieces of paper.
Very sophisticated.
I'm so sophisticated. I have a separate little camera which hangs on the monitor and of course ends up in different places every time I move it or pull the cord by mistake. But
Are we
because
missing?
I don't want the view from under my chin, is basically. This is bad enough being on Zoom.
Mr. Black's not there unless you can hear us, Mr. Black. We can't see you. We see, looks like a computer tower on the right and a ski lift on the left. Is that Gateway I'm looking at, Mr. Black?
I'm not exactly sure. As one of my jobs in the old days before state government was to work at the Santa Fe ski basin. And it could be Gateway. I'm not sure. I haven't been up there ever since my laminectomy and spinal fusion. So
Whoa.
I probably will never be up there again. Skiing.
That was
anyway.
ambitious.
It is Gateway. I already knew the answer to the question. I thought I'd impress you.
Are they
And
doing
for
a
people
whole
who
lot
don't
of?
know what that is, that's the name of the trail
Hmm.
at the Santa Fe ski basin that this picture is. And I'll step away so you can see.
Yeah, that's
Yeah,
definitely no
that's
doubt.
without snow, though.
It's
Are
what's
they doing a lot of skiing right now? Because last night I have a view from my house to the mountains, and traditionally you see like one light up there late at night grooming. And last night it was like a whole row of them.
That's snowmaking on Gateway, a matter of fact,
Is it?
on that same slope of the photograph.
And it could be grooming machines as well.
Yeah, I mean, the bright lights, I
They
assume.
move.
The machines move. Oh, the stomach makers. But usually it's been one. And then like it was a whole little chain of little lights. That's right.
All right. Yeah. Excuse me a second. My phone just beeped at me. I think everyone is here. So rather than end even later in the day, we'll begin right away. Ms. Stevens, are you ready to present your case?
Yes, the city calls Miss Lisa LaRock.
Thank you. Please swear her in, Mr. Lee.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Your witness.
Good afternoon, Miss LaRock. Would you please give your full name and title for the record?
Yes, my name is Lisa LaRock. I am the Sustainability Officer for the City of Las Cruces.
And did you prepare some direct testimony in this case in December?
Yes, I did.
Do you have a document in front of you that's been pre-marked as CLC Exhibit Number 1?
Yes, I do.
Is that your direct testimony?
Yes, it is.
And was that prepared by you or under your direction?
Yes, it was.
And if I were to ask you the same is it true and correct? If I were to ask you the same questions today, would you give the same answers?
Yes, I will.
And
Yes,
are those answers true and correct to the best of your knowledge?
yes.
Do you have any changes or corrections to make to your testimony, Ms. LaRock?
Yes, I do.
And where would that be?
It's on page 6 of the testimony, or 8 out of 48 in the PDF numbering.
And what changes this?
It's on page 6 and it's lines 14 and 15. I'd like to strike the whole number 7. Which is address EPE's proposals for recovery of EELM plans, expenditures and claimed investment incentives for prior periods dating to its last EELM plan case.
And what is the reason for that revision to your testimony?
Because I was not able to do it in completion.
So that there is no section of your testimony that
That's correct.
relates to item 7, is that right?
Yes.
Okay. And are there any other changes or corrections?
Not on my direct testimony, no.
Before you go any further, I noticed that you would then have two item 6s. Is that correct?
Actually, thank you.
Oh, is that another error?
Examiner, another error. I just.
One at a time, please.
Oops.
Actually, thank you. You said, Ms. LaRoe, go ahead.
There is another correction on line 16 on page 6, which is to change the number 6 to a number 7 in parentheses.
Okay. So again, with that change, those changes, Ms. LaRock, if I asked you the same questions, if you were asked the same questions under oath today, your answers would be the same?
Correct.
And these are true, these are complete and thorough answers to the questions?
Yes.
The city moves to admit CLC exhibit number 1, the direct testimony of Lisa LaRock.
Well, let's see if there's any objections. Mr. Simpson, is it okay?
Yes, it's okay. No objection.
Thank you. Mr. Black?
All right, thank you.
Thank you. Ms. Lynch?
No objections.
Ms. Olson?
No objections.
Wonderful. CLC number 1 is in evidence. It will be considered as evidence. It's admitted.
Thank you. Now would you look at the document labeled CLC exhibit number 2?
I have that in front of me.
And is that the direct testimony of Jose F. Provencio on behalf of the city of Las Cruces that was filed on December 17, 2021?
Yes.
And in light of Mr. Provencio's inavailability, is it your intention to adopt and testify about that testimony today?
Yes, it is.
Ms. LaRock, first of all, obviously you need not address, you're not adopting his qualifications because you are you, but can you tell me whether you were involved and aware of this testimony as it was being developed in December?
Yes, I was.
And since Mr. Provencio asked you to substitute for him, have you refamiliarized yourself with his testimony?
Yes, I have.
And do you believe that it's true and correct to the best of your knowledge right now?
Yes, it is.
Are there some sort of corresponding changes to be made in this testimony as in yours?
Yes, there are.
Well, why don't we go there?
On page 10 of this document, which would be 12 of 26.
Yes.
On line 20, to strike the last sentence beginning with, in her direct testimony, city witness Lisa LaRock raises questions, and that continues on to page 11 on lines 1 and 2 that say about EPE's expenditures and claim incentives under the case programs for 2019 and 2020.
And is there another change about?
Yes, on page 11, further, the first sentence starting on line 6, where it says, first, the commission should consider whether to disallow some of EPE's claimed costs and incentives as discussed by Ms. LaRock. That should be deleted. And then continuing, we would keep as EPE witness Araceli Perea acknowledges, and then strike and Ms. LaRock discusses.
Okay. And again, is the reason for that that was not covered in your direct testimony?
That's correct.
And to
Those
the
are all the
extent necessary, have you confirmed that Mr. Provencio's testimony, which you're now adopting, is accurate as of today? And
yes.
And if I were to ask you the same questions today under oath, starting with section 2 of the testimony, would you give these answers?
Yes, I would.
The city moves to admit CLC exhibit number 2, Provencio's direct testimony. I don't know whether I should relabel this, Mr. Lennon, as being adopted by her.
You
I
know,
don't think so.
it's a case of first impression for me, the adoption of someone else's pre-filed testimony. So I'm going to see if any of the other council have any objections and let them argue if they do, and we'll take it a step at a time. As for as for changing the label is actually whatever I say it is as we admit it, not whatever it's pre-marked. That's the way I look at it. So a lot of parties like to pre-mark them, and we'll use whatever they pre-marked them. But to me, it's still CLC number 2, but for a different reason than you pre-marking it. That was a very long answer to a very easy question. So okay. I also have that problem. You can just read that however you like. So let's see if anybody else has any objection to what's now labeled as CLC number 2. First, we'll go with Ms. Olson. Any objections?
I have no objections. I think it's clear from the record that the testimony is being adopted by Ms. LaRock as if it were her.
Any questions about whether it complies with our normal pre-filing and subjecting the pre-filer to cross-examination?
No, at this point, my interpretation is the pre-filer is irrelevant. This is Ms. LaRock's
adopted,
and she's standing for cross-examination on the subject matter.
Even though it was pre-filed by another witness or another party on behalf of the witness. Okay, I understand, and that's fine. Now, Mr. Black, do you have a position on it?
Thank you, Mr. Hearing Examiner. The staff takes no position on this extraordinary change, although staff does not oppose. And Ms. LaRock and Ms. Stevens, please send my thoughts to Mr. Provencio. I hope he has a fine and quick recovery.
Okay, Mr. Black.
Thank you, sir. Miss Lynch, please. Any objection to the admission?
No objection. I've seen this practiced in this forum before.
Oh, I'm sorry. You introduced the evidence, didn't you? I mean, I'm sorry. No, it's CLC. Just sorry. I had a brain problem there. Okay, so you have no objection, Miss Lynch. Got it. Thank you. Mr. Simpson, any objection?
No objection, Your Honor.
Okay, well, I had to think about this for a little while, to be honest with you. You've seen it done in other forums, the adoption of another party's witness. I didn't have a big problem with that because at that point, I believe it becomes her testimony once she adopts it, and then she's subject to the to cross-examination. My only problem with it is we have this, procedural rule that has to be pre-filed. And it was pre-filed by, I rationalize it pre-filed by City of Las Cruces rather than pre-filed by this particular witness. So to me, that disposes of that issue. And the fact that it's being adopted subsequent to the admission is relatively insignificant. And as long as the other parties don't have any problem with it, I'm good with it. So CLC number 2 is admitted as evidence. You're welcome. Is that your case, Ms.
And
Stevens?
I tender Ms. LaRock for cross-examination.
Great. Go ahead, Ms. Laura. Let's see, who should we go first with? Mr. Simpson, we've never called you first. Are you interested in cross-examining first?
Sir, I have no questions for this witness. Thank you.
Thank you. In that same line, we'll go with Mr. Black. Do you have any questions, Mr. Black?
Thank you, Mr. Hearing Examiner. Staff has no questions for Ms. LaRock in her individual capacity as her witness, or for Ms. LaRock in her capacity as adopting the testimony of Jose F., as in Frank Provencio. So we don't oppose.
Very thorough. Ms. Lynch, any objection? Do you have any cross-examination?
At this point, we don't have any cross-examination of Ms. LaRock. Thank you.
All right, and I kind of saved you for last on purpose, Ms. Olson. Do you have questions?
I do, Mr. Hearing.
Please.
Good afternoon, Ms. LaRock. Nice to see you again.
Thank you.
Feel like we're getting to know each other. We've been in a few of these proceedings before. You'll be happy to know I don't have extensive questions about your background. So
Thank you.
but I just have a couple. So you are the City Sustainability Officer. I think you mentioned that in the beginning.
True.
And the City Sustainability Office is a separate department. Is that a correct term from the City of Las Cruces Utilities?
I'm a section in the city manager's office, and utilities is a separate department.
Okay. And I noticed in Mr. Provencio's testimony, he said formerly known as the Las Cruces Utilities Department. Now it's just called the City of Las Cruces Utilities, but it is in fact a department still for.
Yeah, it has a unique standing in the city because it uses enterprise funds and is responsible for truing up its budget in a different way than the operational funds that are used in the rest of the city. That's why.
Okay, thanks. That's helpful background information for my knowledge. But and so I guess the confirmation I was looking for is those are separate department. You two aren't in the same department, and you've clarified that.
20% of my salary comes from utilities, but I'm not supervised by them.
Okay, and you function independently from the utilities department. Okay,
Yes,
and
sorry.
so just a point of clarification, I think your testimony mentions the city is coordinating with EPE and MFA to offer additional low-income retrofits through the proposed new energy smart program, correct?
Correct.
And then do you happen to have Mr. Provencio's testimony in front of you?
Yes.
Okay, and if you could just turn to page 7.
I'm there.
Okay, in this section, it's titled Low Income Program Collaboration with the City. And this section discusses a collaboration between the city, EPE, and gas utilities to add measures to the utility saver program. Is that correct?
Yes.
And so is the city collaborating with EPE on both of those programs, the new Energy Smart program, as well as the Energy Saver program?
I believe it's talked about it, but I don't think that the MOU has been finalized.
Okay, and the city is contemplating separate MOUs, one for the Energy Smart program discussed in your testimony, and then a separate collaboration for the Energy Saver program discussed in Mr. Provencio's testimony. Is that correct?
Yes.
Okay. And is the sustainability office directly involved in that collaboration, or is that a collaboration between the City of Las Cruces utilities, EPE, and the MFA with respect to the SMART program?
I didn't understand the question, Ms. Olson.
Sorry, I phrased that poorly. So starting with the collaboration on the Energy Smart program,
Right.
is that a collaboration with the City of Las Cruces utilities, EPE, and MFA, or is that with the sustainability office?
It's with utilities.
Okay, and so obviously you both are representatives of this city, but is Mr. Provencio the point of contact for that collaboration?
I believe that he is, but I can't say definitively.
Okay, and you're not directly involved in that collaboration, is that correct?
That's correct.
Okay. And is the same true for the other collaboration for the Energy Saver program?
They're both together, yes, for utilities. They're both under utilities.
Okay, and you're not directly involved in either collaboration, is that correct?
No, I'm not.
Thank you. And have you reviewed the direct and rebuttal testimony that was filed by EPE in this case?
Yes, I have.
And you've reviewed the separate testimonies of Ms. Perea, is that correct?
Yes.
Ms. Martin?
Yes.
And Mr. Hernandez?
Yes.
Okay. Just in general, are you familiar with the utility cost test?
Yes, I am.
And is that, is doing UCT calculations something that is a part of your position as the sustainability officer within the sustainability office?
There are many. Do I follow the specific guidelines of the UCT? No. Do I do a lot of calculations to look at the veracity of the efficiency of energy? Yes. And its cost. Mm-hmm.
But do you
do I run UCT tests? No.
I'm sorry, one at a time, please. Do
you perform UCT calculations specifically in your role as the sustainability officer?
No, that falls more under the purview of Joe Provencio.
Okay, and are you aware of whether Joe Provencio does UCT calculations?
I believe he does.
Okay. Are you aware of Mr. Provencio running UCT calculations in this case?
No, I'm not.
But it's your understanding that he would have the ability to be able to do UCT calculations if he was asked?
Probably.
Okay. And is it your understanding, just from a high level, that the UCT calculation is a benefit cost ratio?
Yes, and benefit cost ratio can be broadly or narrowly defined. Mm-hmm.
Sure. And is it your understanding that the benefit in that ratio is the measure savings? So either energy or demand savings.
Yes,
And are you familiar with the New Mexico TRM? I believe it's Technical Resources Manual. Is that correct? And are you
For the
familiar?
record, you nodded affirmatively, correct?
yes, I did say yes as well.
Oh, I didn't hear it at all. I'm so sorry.
And are you familiar with the process that's used for developing and updating that manual, the TRM?
Generally, yes.
And do you agree that the TRM is updated by the state of New Mexico's independent evaluator?
Yes, yes.
And that that evaluator is appointed by the PRC?
I didn't know that, but I believe you.
And is it your understanding that the TRM is provided for utility use?
Yes, but I find it a useful resource regardless.
Sure. And do you agree the TRM identifies approved energy efficiency measures?
Yes, it identifies, it's not all encompassing. It identifies a portfolio of measures.
And do you agree that the TRM is the source of savings for those approved measures?
Yes.
So moving specifically to your testimony regarding EPE's residential lighting program and lighting measures, you generally oppose continuation of the residential lighting program, is that correct?
Yes.
And you also oppose inclusion of lighting measures within EPE's residential programs, is that correct?
Yes.
You provided non-binding recommendations to EPE before it filed its case, is that correct?
Yes.
And those non-binding recommendations, I believe, are included in the record as AGP 1R, an exhibit to Ms. Perea's rebuttal testimony, which has been admitted in the record as EPE Exhibit 2, is that correct?
That's correct.
And do you have any, do you agree that that exhibit accurately represents the non-binding recommendations that you provided by email?
Yes.
And with respect to those non-binding recommendations, you didn't make any specific recommendations regarding the lighting measure at that time, is that correct?
I would have to go back and review it again, but that was not to meant that those set of recommendations were not meant to be totally a total commentary on all of the portfolio that El Paso Electric was offering. It was specific recommendations that I thought were limiting the full capabilities of the portfolio as it stands.
Just in response to the question that I asked, you didn't make recommendations regarding the specific lighting measure at that time. Is that accurate?
I would have to go back and look at it. Do you want me to go back and look at it?
Yeah, we can go back and look at it. It's EPE Exhibit 4. And it's AGP 1R, pages 1 and 2, at the end of that exhibit.
This is on Araceli's, right? Okay, yeah.
That's correct, her rebuttal testimony.
I got
Give
it.
the exhibit number.
So,
Did you say EPA exhibit number 4? Isn't it 2? It's the Perea rebuttal.
That's
Excuse
correct,
me.
Hearing Examiner. If I said exhibit 4, I misspoke. It's EPE Exhibit 2, and
Okay.
then exhibit AGP 1R to that exhibit.
Page 1 of 2?
Pages 1 and 2. That's correct.
1 and 2. Okay, sorry, I just went to the wrong place. Go ahead.
To answer your question, the lighting measures were not included in there, but I do not understand the problem of or the inconsistency of making non-binding recommendations and having my direct testimony expand on areas that were not covered in this non-binding recommendation.
I don't believe I said anything about inconsistencies. I just asked if you had made those recommendations when you were giving initial comments before EPE filed its case. And the answer I believe you gave is no.
Correct.
And turning to the residential lighting program specifically, is it your understanding that that program is in fact one measure, the LED bulbs?
I'm sorry, I hear the end of your question.
Looking specifically at the residential lighting program, is it your understanding that that program is a single measure, the LED bulbs?
Yes.
And you agree that that measure, LED bulbs, is an approved measure in the New Mexico TRM?
Yes.
And you agree that the residential lighting program produces savings? We're talking historically.
You mean net savings, like a positive UCT number, or do you mean just savings regardless of cost? I don't understand your question, Ms. Olson.
Well, we talked previously about how the UCT is a cost benefit calculation, and the benefit in that calculation is savings. And I'm asking if the residential lighting program produces savings.
Okay.
And my answer is that yes, the light bulbs produce savings, but in the portfolio of TRM measures that are given and the broader spirit and intent of the Energy Efficiency Act, I find it problematic that there is no broader context that's applied when selecting the different measures that are out there.
Okay, but we're talking about the lighting program, which is a single measure, LED bulbs, and we're talking specifically about whether LED bulbs produce savings. And I believe I heard your answer was yes.
I said they do produce savings, but they're they've also been accepted broadly and are, that they are a pervasive accepted practice and aren't purposeful in terms of promoting new ways to save energy.
Okay, well, let's stick to the questions that we're asking, though. We can get into to areas outside of the residential lighting program, but right now we're just specifically talking about this program. And you agree that the residential lighting program to date is cost effective based on the information you have?
I actually am not. The information that I have says that lighting, according to the U.S. Energy Information Agency, only accounts for 9% of the total electricity that is used by a household. So trying to make a small dent in 9%, or even other reports have said up to 12%, seems like an insignificant contribution compared to the other 88% of electricity that is used in a household. So yes, and as a single measure it may be, as an impactful measure, no.
Okay, Ms. LaRock, I appreciate that you have a lot of opinions on this, but if you could answer the questions that I'm asking, I would appreciate this. And I think it will get you off of the stand much more quickly. I think you were afforded the opportunity to give your direct testimony and testify to all of these subjects. And so now is my opportunity to cross-examine you on a very discrete portion of your testimony. And so the question I'm asking you is, applying the UCT calculation, and I think we can go back and look at reports if we need to, but I'm hoping to avoid that. Is it your understanding that under the UCT, the residential lighting program is cost effective?
No.
Okay, let's look at the 2020 annual report, which I believe is the City of Las Cruces is Exhibit 19.
I'm sorry, where do you want me to look?
It's CLC Exhibit 19.
Okay.
And if you can look at looking at the page numbers at the bottom of the report, if you look at page 2.
Oh.
And it's table 2.
I'm there.
And then if you look down under residential, you'll see residential lighting program. And if you go all the way to the right under UCT, it looks like the number is 3.74.
I see that.
And so is your understanding that a UCT of 3.74 is not a cost effect, does not establish cost effectiveness under the UCT?
My problem with the calculation that was derived is that it uses the TRM to establish what the energy efficiency of a light bulb is. And then it uses a TRM to calculate that I have distributed 1,000 light bulbs. Each light bulb is a savings of 10 kilowatt hours. Therefore, I've saved 10,000 kilowatt hours, and that translates to a certain price in there. But the problem is that there is no field confirmation for me to say that that number is accurate, because El Paso Electric only uses the manual for its pre and post check by saying that the number that are distributed is the number of the savings. So yes, at face value, it does look like it's a good program, but in reality, I can't say definitively because there is no field check that's in there. I don't know if everyone's using those light bulbs that are distributed. And I also don't know its effectiveness based on people just taking free swag because it's available, as opposed to really using that material. So in that sense, I'm not confident in the veracity of that data.
And before you go any further, let me ask a question, because I might forget later. And is it true that you don't know whether they are using the light bulbs either?
From my understanding and the way that it's treated, even in calculations that we've done with energy performance contracts, is that there is, the TRM says there's a given savings, the expectation, and that they assume that savings will occur. And so the post reading is the savings that's listed in the TRM. Well, so there isn't a field check or any sort of meter that says, yes, this is the number of hours.
Are you finished?
Yes, sorry.
And is there a field confirmation that the bulbs are not being used?
There is no field confirmation in any way, so I have no way of saying that they are or they're not.
Thank you. All right, you can go ahead, Ms. Olson.
So again, Ms. Rock, I'm going to ask you to answer the specific question that I'm asking. It sounds like you have issues with perhaps the statute and the TRM and the savings that are derived from the TRM. And that is, again, something you could have raised in your case in chief. But the question.
Objection. Miss Olson is testifying here.
Yeah, I was waiting for the question, Ms. Olson.
Or providing rebuttal testimony.
Sustained, so please don't testify, Ms. Olson.
The question that I'm asking you is, does the lighting program, the residential lighting program, meet the UCT cost effectiveness standard?
Objection. I'd like a clarification as to whether Ms. Olson now is asking about the historical figures or the prospective ones in the plan, because we did bounce back to she did take Ms. LaRock to the 2020 verification process.
Well, number one, the answer is obvious if you look at what she took it back to. And number two, we can easily resolve the objections by instructing the witness to answer for both circumstances. So past and future. Go ahead, Ms. Olson, if you want to reconfigure your question so that she'll respond to both, then there's no objection to rule on.
Okay, I believe I had directed Ms. LaRock to CLC exhibit 19, page 2 of the 2020 energy efficiency report, where we have the UCT for that program there. And I'm asking Ms. LaRock to confirm that the residential lighting program meets the UCT cost effectiveness standard.
For what year?
Objection met or meets. We're back to the question of historical versus prospective.
This is 2020.
Look at a specific document and answer a question related to that document. I don't think there's any ambiguity.
Overruled. To number 2020, table 2, and this is historical data, and it shows 3.74. Am I missing something there?
No.
Ms. Wilson? No. And Ms. LaRoque? No. And Ms. Stevens? It says 3.74. Am I missing something?
As long as we're still in historical, no.
Well, 2020 seems to be a year before 2021, and we're now a year later in 2022. I don't know, it sounds historical. So is there another UCT you were asking about, Ms. Olson?
No, I believe Ms. LaRock's testimony in response to the question that I initially asked when I said,
The UCT, what is it?
did the program meet the UCT cost effectiveness standard? Ms. LaRock said no, and so I directed her to the 2020 report, and I'm asking her again, did the residential lighting program meet the cost effectiveness standard in 2020?
Well, she said no, so why don't we find out why she said no?
I did answer.
Ms. LaRoque, why is it your opinion that the UCT was less than 1, as you just testified?
I don't feel confident that that data is totally accurate for multiple reasons. One of the reasons is that there has been no field testing to see whether the light bulbs have been used or not. So that data could be inflated. The other thing is that there's been no that there's, even if it is field tested, there's no field testing either to see whether it was used or how long the lights were used. And I also think that there are, that this data, my objection with this program is not the UCT per se, but it has to do with the UCT, I'm sorry, the spirit and intent of the act. And I believe that light bulbs have already been broadly accepted in the community. And so the purpose of driving energy efficiency is really a moot point, because people would be getting LEDs regardless, and it isn't driven by this program. And so although the calculation may pencil out to show those numbers, I don't think it's a good measure. So I feel constrained to answer yes or no to this question, because it doesn't talk about that broader issue for me. And I thank you, hearing examiner, for asking for clarification.
Well, I appreciate your answer as well. And I'm sorry to interrupt you, Ms. Olson. I don't like to do that, but sometimes I just have a question I need to ask. And you stated that these people would be getting LEDs regardless. Why would they be getting them if not to use them?
Well, I'm saying that I feel that this program can serve many functions, one of which is to promote new technologies, advance new technologies, so the adoption rate increases. That was the case that Mr. Simpson was trying to explain in terms of the heat pumps. In this case, I feel like people, if they are taking advantage of this program, are taking light bulbs because they're free. Because the same reason I would pick up a squishy thing if it was on a table, or a piece of candy that was given out for free. It doesn't have to do with something that I necessarily need or can't afford or don't already have in my house. It's because of the interest in getting something for nothing. And in that case, or for a discount at home, at the stores, that is another reason that you would buy something, because it's on sale. But by and large, I don't think that this program is driving people to do something that they normally wouldn't other do. And if you have a certain budget that you're working from, why waste it on something as commonplace and pervasive as an LED? That's why I object to the program.
I understand your testimony. It's, I'm sure you believe makes sense. I'm trying to reconcile, so that I understand your testimony. Why would people that would search out, and using your words, quote, would get LEDs regardless, unquote, not then also use LEDs that they receive in a program regardless of the price?
Well, they would, but I'm saying
Exactly.
that they could, that's fine if they take advantage of bulbs. I have picked up LED bulbs from EPA whenever I see them, and my drawer is full of them, just in the off chance that one will fail and I replace it. But the point is that if the energy efficiency program and load management program is to have a significant role in the community, then why would you want to spend such a disproportionate amount of money on lighting when you could be driving other things that are of greater importance and need for the community?
Well, isn't that what the UCT tells us?
Well, the UCT tells you that something is cost effective in terms of dollars and kilowatt hours but or demand charges, but it doesn't tell you what the other benefits are that are important to the community. So benefits like helping electrification would be more significant if you were promoting heat pumps or water heat pumps. If you reducing cost burden by having insulation would be more significant to the community than light bulbs. And dealing with issues of overall efficiency like heat pumps, again, for resiliency, so customers, especially low and moderate income customers, don't rely on evaporative coolers that wouldn't work in extreme heat events, which are much more prevalent now than they ever were and are continuing to be. So those are the concerns that I have. I'm not saying that the measures don't fall under the guidelines as described by the UCT, but I'm saying that of the measures and of the great importance and that this program could contribute to the government, to the community, I think it falls short in addressing other needs that could serve to help in many other ways than meeting a UCT.
Are you stating that one of the criteria to be decided is whether importance to the community, specifically the Las Cruces community, is something that should be the criteria to determine whether to approve the application, and specifically the pass-through of the cost to the ratepayers?
Could you repeat your question, sir?
I was clear.
Okay. I think from what you said, that there is a way to have a win-win, that you would find cost-effective measures that also work towards improving or lowering cost burden, increasing thermal comfort, especially in low and moderate income communities, that drives adoption of new technologies like heat pumps. Those are things that this program can and should do because of climate change, because of impacts on our communities. And I mean, the measures that are here, you know, follow the law, but they could do so much more. And under such pressing circumstances that we're all feeling, I wish that they would. But in, you know, EPE's defense, I want to say their partnership with MFA and other partnerships is laudable. I think that their work with the people with the low income community that had COVID and how they were extending that was appropriate. I'm sorry, Miss Olson, is something funny?
So you please don't ask questions, but I'll be glad to ask for you, Mr. Rourke. Ms. Olson, we would appreciate your undivided attention. I know there's somebody outside of the frame that you may be talking to, but I have actually noticed it a couple times as well. If you could just give us your attention, including attention to this witness, I would appreciate that. So Ms. LaRoque, you kind of interrupted yourself and it gave me an opportunity to ask you a question. I thank you for your response. I think it's heartfelt. I have no doubt that you have the best interest of the constituents of Las Cruces in mind. This is a state agency applying a state law and state regulations. And you mentioned that we are following the law, which frankly leads me to the understanding we could create here. Your relief, if any relief is to be had, so to speak, would be with the legislatures. So the type of relief you're describing is perhaps a change in the law. And that's just something for you to think about. I'm not trying to telegraph to you what I'm going to put in my recommended decision. I have not even, I'm not even close to that stage at this point. I'm trying to understand your testimony. And I did read your testimony before you're testifying today under cross-examination. But it left me wanting, trying to figure out, it seemed that you, and I don't mean this in any bad way, but you were so focused on the bark that you're missing the trees of the proceeding. And that's why I was hopeful that today you could clarify. And honestly, you have clarified through the cross-examination from Ms. Olson and a couple questions that I asked you. So I'll appreciate that. And I want to let you know that I appreciate it. And it's well taken. And I don't have any other questions at this time. And I want to apologize to Ms. Olson for interrupting your cross-examination. I really try not to do that. But frankly, I forget sometimes if the cross-examination ends a half hour later, I forget what I wanted to ask in the middle. And sometimes if I do it in a timely way, it helps me with my case. So Ms. Olson, if you would please continue with this witness, we'd appreciate it.
Sure, and I apologize, the remote setting is awkward. We're not in a hearing room, so you don't get the full picture of everything that's going on with each other. And I absolutely don't mean to have me trying to get all these documents together and get help with that come across as rude. So I apologize, Ms. LaRock. I do have respect for you and your initiatives, and I hope that that's not how that's taken. Okay, so moving on, it appears that a lot of the comments that you're making in response to concerns with the program and the hearing examiner questions go to free ridership. Is that fair characterization?
Yes, I think so.
And are you aware, or do you agree that the statewide independent evaluator actually determines free ridership inputs?
Yes, I do, but I understood from what Amy Martin said that in Phil Simpson's questioning, that there was some latitude for discussion.
Okay. And so to kind of sum up where we are, we've talked about the UCT cost effectiveness of light bulbs. We've talked about the approved measures in the TRM and that savings come from the TRM. And so I want to now turn to what I view as the principal basis for your recommendation, and that goes to the impact of pending legislation. Is that fair?
I'm sorry, I'm not clear on that last question.
Yeah, it seems like one of your principal concerns with the program is the impact of pending legislation. Is that correct?
Oh, you mean with the lights?
Yes.
Yes.
Yeah, going back to the specifically with the lighting measure. And your testimony uses words like inevitable and imminent to describe anticipated changes in law. But at this point, we don't know if or when those proposed changes will actually be adopted or take effect. Is that correct?
No.
Yes,
and correct. Sorry.
The timing on that can be impacted by any number of factors, correct?
Yes, they could be faster or slower.
Including changes in administration.
I hope not.
And as past experience has shown, unfortunately, it may not be a change that happens during the course of the first year of the plan. Is that correct?
It would be difficult for me to say, but yes.
And until that change actually happens, is it fair to say we don't know exactly what the impact of that change in legislation will be?
Yeah, yes.
And sorry, I'm just trying to catch up here on my notes. You'll be happy to know I'm almost done. I just want to move quickly to the subject of reconciliation, which I believe is part of your testimony that you've adopted from Mr. Provencio. And I just have a very brief cross-examination on this. Listening to the city's cross-examination of Mr. Hernandez, it appeared that the city's primary objection to the reconciliation proposal is concern about over collecting the reconciliation amount, leading to a subsequent underage. Is that correct?
I think that there's several things that are of issue to the city in that respect. I think Ms. Stevens's questions related most to the overage and underage, but there's also issues about timeliness of the ask, of the breadth of your description for the reasonableness for your request for the variation, and also that normally I believe the rules say that the adjustments should just be made within the triennial review and not carried on into other years. And so those are some of the other areas that we've touched.
And would you agree those other areas, interpretation of the law, interpretation of timing of the requests, those are largely legal issues?
I do agree they're legal issues.
Okay, so turning to the factual concern, and the subject of Ms. Stevens' cross-examination, I believe you were present during that cross-examination, is that correct?
Yes, it was.
And do you agree that a subsequent under over collection would be resolved through a future reconciliation? And I'm not asking you.
The problem that I have in answering that is that reconciliation is not a concept in state law or statutes that currently exists. And so having clarification on that would be important in determining whether it's possible.
Sure, and I'm not asking you a legal question. I understand that you're not a lawyer, and so I'm not asking you whether the law allows for reconciliation. I'm merely asking, could a underage or overage be addressed in a future reconciliation?
I can't answer that.
So you don't know whether it's possible to address under collection?
Objection asked and answered.
Yeah, she answered, and the answer is the answer. She doesn't know whether it can be reconciled in a subsequent true-up or whatever you want to call the operation. I mean, it's not a great answer, but that's her answer. So
Okay, move on.
sometimes it's good to get not a great answer and not good to clarify.
But I thought I'd answered it with the previous question when I said that it was
Ms.
not.
LaRoque, there was no question for you to answer, so
Okay.
it's better to just answer when there's a question. And Ms. Olson, is that the conclusion of your cross-examination?
No, I have a couple of additional questions.
Please.
Do you agree if carrying charges were approved in this proceeding that an overcollection would be subject to carrying charges?
Yes, if there
The
was
city
a reconciliation.
I'm sorry, what was that?
Yes, if there was a reconciliation allowed, then the carrying charges would be plausible.
But the city is opposing applying carrying charges, is that correct?
Yes, because there's still some unresolved rules related to that. So it's difficult for us to support something that doesn't have clear legal guidelines.
Ms. LaRoque, are you testifying to the law?
Sounded like it, but that's her answer. Like I said, sometimes it's good to get a bad answer when you're examining. Unresolved rules related to that was her answer.
Hearing
I don't
exam-
want to cut you off, Ms. Olson. I'll ask her. Maybe it'll help a little bit. Ms. LaRock, exactly which rules are you referring to when you state there are unresolved rules?
In Jose's testimony, well, in the testimony that I've adopted, there was some decisions that were made about the carrying costs, and not all of them were decided on. So from my understanding, there are still some points that have been left unresolved. So it's difficult to know whether or not those changes in the rules will impact positively or negatively for the city and its residents. I know that some of the carrying charges that are month to month are quite reasonable, but sometimes there's, because of the lag time in some of the costs that are incurred, like with the incentives or determining when all the costs are there, that might mean a big burden on ratepayers to have to incur those extra carrying costs. And if that stands to be true, then it's a problem for us that we would want to object to. And until those rules are clearly stated, we don't know if El Paso Electric is doing them within the guidelines that's been provided, or whether or not it's something that we should be concerned with. And that's how I am trying to navigate between legal and our general concerns for overpaying as a rate.
When you speak of a rule, are you referring to a New Mexico Administrative Code section?
Administrative.
NMAC?
The PRC rulemaking that goes along with this, with the
Body of law?
reconciliation.
Could you show me in Mr. Provincio's testimony the site to the rule, please?
Just a minute, please.
Thanks. So let's start on page 12 at the bottom, where it says, do you have concern with EPA's proposed EUREF? And then I could be wrong. That's just what I see. Because
I think it is in on page 17.
okay.
On lines the 14, 15, 16.
I see actually the words unresolved issues. Apparently that was a statement made in case number 19-00168. Is that correct? So the site is actually to a case rather than to a NMCA, NMAC section. Is that correct? In the final order, adopting amendments to the rule?
Yes.
So my position on that, I don't mind, it's pretty clear. is that a rule's a rule, and until it's changed, it's the same rule. And when it's changed, it's a different rule. Until it is, it's not. And I'm not going to comment on what frankly appears to be some sort of, I'm not sure, I didn't read it, but dicta as to a future change in a rule, which was made in a 2019 case. And it's kind of vague what he testifies to in your adopted testimony. Unresolved issues really doesn't tell me much. Could you put some meat on that and tell me what's the nature of the unresolved issue?
I don't think I could do it justice.
Well, I don't either, based on what I see on page 17. And it's, although I don't mind looking up stuff, I have Lexis and I can kind of just put in a few numbers and annotations and stuff pops up. You know, it's not really my job to do that. And I don't take an active role in litigating because I let the litigators litigate and I let the parties put on their case one way or another. But frankly, if you're going to rely upon it in your testimony today, I would really depend on you to explain it.
I appreciate that, hearing examiner. I believe this is somewhat extenuating circumstances. We were between a rock and a hard place of not being allowed to not include this. And so I stepped in and tried to review it to the best of my ability with a day and a half to do it.
Okay, well, you're a good employee, obviously, and that's wonderful. Ms. Olson, would you care to, are you finished now, Ms. Olson?
Mr. Hearing Examiner, it sounds like this line of questioning is not going to be helpful because there's some confusion on what Mr. Provencio meant, and so I'll stop.
Okay. You know, there's a lot of tricks to practicing law, and one is to know when to stop talking, and that's a good thing to know. So I believe I asked every other lawyer for every other party whether they had any cross-examination. The answer is no. Did I miss anybody? Okay, thanks, because sometimes I do. Ms. Stevens?
I have a couple of questions on redirect.
And within the scope of the cross-examination, please.
Yeah, well, of
Thank
course.
you.
Hi, Ms. Thorak. First of all, do you need a break?
I'm fine.
You sure? Okay, Mr. Lee, do you need a break?
No, ma'am.
Okay. Ms. Olson asked you a lot of questions about the New Mexico TRM, or Technical Resource Manual. Do you recall that? It was a little while ago. Is it your understanding that she used the term approved measures, and you seem to accede to that term? What is your understanding of whether a measure that appears has some data in the TRM? Does that how does that make it an approved measure?
From my understanding, it says the TRM provides it provides measures that could provide energy efficiency, and provides different data points depending on units of size and things like that. It's a menu of ideas that's used as a general reference, and it's used specifically by the EELM program, but I don't know if it doesn't necessarily mean that that you have to use them. It's just a menu of ones that are available.
And do you, is it your understanding that the TRM tells you whether a particular program as offered by a particular measure as offered by a particular utility will pass the UCT test, or does it just provide some of the inputs?
It just provides some of the inputs.
You said the utility doesn't have to adopt all these measures, all the measures that have some data in the TRM. Has El Paso Electric, in this case, proposed to incorporate all of the measures that have data in the TRM?
No, I don't believe so.
So the company has exercised discretion in choosing amongst.
That's correct.
And let me just check. I think that was the main part of my question. Let me just check one more thing. I think that's it. Thank you very much, Ms. LaRock. And we appreciate your testifying for Mr. Provencio as well. I
Yeah,
haven't heard from
he'll
Mr.
be here.
Provencio.
I want to put that on the record, please.
Yeah, she's looking for some payback at some point.
Well, I hope you can take care of her. The next, I wanted to make sure there's no recross, and that was such a short redirect. I'm thinking no, but I'll ask anyhow. Miss Olson first.
No, but I appreciate you giving me the opportunity to speak again. So I can thank you, Ms. LaRock, and I appreciate listening to you. I do learn something from you every time. So again, it's nice to see you.
Mr. Black.
Thank you, Mr. Hearing Examiner. Nothing from staff at this time. Thank you.
Thank you. Mr. Simpson.
Nothing, Your Honor.
Thank you. Miss Lynch.
I just want to say thank you, Miss LaRock. It was illuminating.
Well,
You'll have to
Take
tell me
care.
what that means later.
thank you, Miss Lorak, for being here. Miss Stevens, it's your witness. You can release her or we can let her go.
I think she'd be delighted to leave. Thank you, Ms. LaRock.
Have a great day, Miss Lorak.
Thank you,
Bye-bye.
everybody. Bye.
Okay, Miss Stevens, does that conclude your presentation of testimony?
It does, thank you.
Thank you, ma'am. So let's, do we want to take a 5-minute break to grab some coffee and use the restrooms? Okay,
sir.
wonderful. It's 2:50 on my thing here, so it shows 2:55. Let's be back. See ya. Hi, everyone. Sorry, I'm about a minute late according to my clock. Ms. Stevens isn't here yet. Okay. We're doing really well. We're off the record, Mr. Lee. We're doing really well. We might even conclude this by 5. That's the plan, at least. Ms. Olson, I think we're on YouTube, so I have to keep that in mind, but I think I owe you an explanation or something. I'm not sure it's an apology, but an explanation. I've been doing this kind of job for 6 years or so, but I was a trial lawyer for like 31 years, and it's, we're just full of war stories, and it's hard to get that trial lawyer out of you. Probably it's going to take me another decade or so to completely absolve myself of all that stuff. So when I make those, I'm thinking in particular of the remark I made to you that and I regretted it almost immediately, that sometimes it's good to know when to stop asking questions. And after I said it, I mean, it's really how I felt, but I have to have some sort of filter and not always say exactly what I feel. And I realized that perhaps it could be interpreted as a inappropriate question. So I hope you didn't, but if you did, I apologize for that.
Hearing Examiner Lennon, your apology is unnecessary, but appreciated. I'm still consider myself a young lawyer, and I'll take feedback in any shape or form. And I also owe you an apology. I hope that you didn't take my side conversation or communication as disrespect to your examining. I was just trying to get a few things together. And so I apologize for how that appeared to you and to the YouTube community. I absolutely take these seriously, and I mean no disrespect to you or any of the witnesses. I appreciate everybody's time and energy being here.
Okay, are we all here now? Oh, we got a new guy, Justin Brandt. How are you, Mr. Brandt?
Very well, sir. Good afternoon.
Good afternoon. I think we're all here. It looks like I look at the boxes on my screen. Mr. Lee, let's go back on the record. Thank you all. We had a slight pause. It's now approximately 2:59 in the afternoon. We took a 5-minute break, which ended up being about 8 minutes. We'd like to conclude the testimony, well, the case for today, at least the evidentiary part of the case. And Ms. Stevens, you're, you're finished, aren't you, Ms. Stevens? You're muted.
I'm muted, Mr. Lennon, because I'm done. Well, I'm not done quite, but I'm done. My witness is done, and thank you. She is not on the screen now because she's going to take a little rest, I think.
Right. Okay. And Mr. Simpson, I believe we had discussed or even possibly agreed that you would be the next in line to present your evidence. Is that your recollection as well?
Yes, sir. That's my recollection.
Okay, are you ready to present your direct testimony and be subject to cross-examination?
Yes, I am, sir.
Okay, back on the record, Mr. Lee, if we haven't already been back on the record, if you would please swear in Mr. Simpson and we'll get this case rolling.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Mr. Simpson, since you're your own lawyer, I won't make any fool for client jokes.
Thank you.
At least not a very good one joke. But there's a couple ways you could proceed, both of them somewhat perilous. One is to just start talking, which is the way that most people do it. And the other one is to play a game where you ask yourself a question and then you answer the question you just asked. So it's almost as if you got two hats and you put one on, take one off. I'm not going to tell you how you should present your case. It's up to you. But those are the two ways that I know of. So you can now proceed, sir.
Thank you, Mr. Hearing Examiner. In cases in the past, I have seen the hearing examiner ask those questions, but if you do not prefer to do that, I can certainly muddle through that myself. I've been taking notes.
Okay, well, I try to stay as far out of the party's business as I possibly can. And I will afford you the same respect and allow you to present your case as you wish.
Okay, I will do it this way. I will give declarative sentences that attempt to answer the questions that I would be asked otherwise if I had an attorney.
Okay.
So I will present my exhibit, which is my direct testimony. It was prepared by me and was never out of my control. It is true and accurate to the best of my knowledge. I have no changes to make to my testimony. If I were asked, would I give the same testimony today under oath as I have written, I would say yes. I have no changes and I would swear to my testimony as written today.
And it's dated December 17, 2021, right?
That's correct, Your Honor. And also I would like to clarify, I emailed out 2 exhibits, my direct testimony as well as some discovery. However, the discovery response does not need to be admitted as evidence because the relevant portions there have already been admitted as evidence, as one of the CLC pieces of evidence. So only my direct testimony needs to be admitted, and I would ask that it be admitted now.
Okay, and it's marked as Simpson Exhibit number 1, right? Right down there at the bottom.
That's correct, sir.
And I noticed that you appear to have signed a certificate of service. That's fine, and you didn't actually sign the thing being served, basically. Am I correct or am I missing a page or anything? I go through page 16 and then 17 is the certificate of service, right?
Yes, sir, I am looking at that. Perhaps when I submitted the exhibit, if you'll bear with me, Your Honor, let me look at, Your Honor, I will look at another file. I may have submitted the wrong file that did not include my affirmation.
Right, that's what I was asking about. Sometimes I lose pages, and usually I see an affirmation or at least a signature line swearing that the above is your testimony or something like that. And I wondered if you were trying to incorporate one signature line for 2 purposes. And if you testify to that effect now, and you're under oath right now, and you refer to it, and we all understand what you're referring to, it's kind of redundant to have a signature page because I think that would satisfy. Oh, here it is. I do have an affirmation page, and there's apparently an electronic signature page on it. electronic signature, just like a S and then your name typed in rather than,
Yes, Your Honor. I believe I erroneously sent in a version that did not include that affirmation page. I'm happy to resubmit that as revised Exhibit 1.
you know what? I don't want to beat up the dead.
Examine here.
Yeah,
I'm looking at Simpson Exhibit 1
right.
and page 10 of 17, and
Right.
there is an affirmation with, as you say, an electronic signature. So I'm
I
not sure
just-
what Mr. Simpson's talking about.
Oh, yeah, I see that now. Well, hold on.
Are
You
we
know what?
okay?
Mea culpa. I think that's Latin for I'm so sorry. I think it's my mistake.
Oh, yeah.
I usually expect to see the affirmation the second page from the end, basically. And then, that's an erroneous presumption on my part that it would be there in all cases. So it is there. And even though it's an electronic signature, which everybody seems to be using these days, you hereby affirm in writing under penalty of perjury that you're over the age of 18 and statements contained in direct testimony are true and correct to the best of your knowledge. Well, so you've got it both. We've got it from you swearing in right now and moving to admit it, that's how I read it. And you've got an affirmation. And I do owe you an apology and everyone else for asking that question. It preceded your resume, which was an exhibit referred to within the testimony. And then it's just a little further before the certificate of service than I expected. So it's my mistake. Let's see if there's any objections, Mr. Simpson. Ms. Olson, any objection?
I have no objections.
Ms. Stevens?
No objection.
Ms. Lynch?
No objection.
And not least, but finally, Mr. Black?
Staff has no objection, Your Honor.
Well, I have no objection. And once again, I apologize for my mistake. Being remedied, Simpson Exhibit number 1 is admitted into the record and is now evidence. Let's subject Mr. Simpson to any questions you guys might have of him. I think it would be appropriate to have Ms. Olson cross-examine him first. So please proceed, Ms. Olson.
Mr. Simpson, thank you for participating in this hearing. I have no questions for you on cross-examination.
Thank you. Ms. Stevens.
City has no questions for Mr. Simpson.
Ms. Lynch.
CCA also has no questions for Mr. Simpson.
Thank you. Staff.
Thank you, Your Honor. Thank you, Mr. Simpson, for appearing and participating in this important matter, and staff has no questions.
That about covers it. Simpson Exhibit number 1 is admitted as evidence, as I said. Let's now have some cross-examination. There is no cross-examination. I'm sorry. You know what happens? I think of 4 things at one time, and it gets confusing sometimes. It's admitted. There's no cross-examination. It makes it easy, Mr. Simpson. There will be no redirect because there was no cross and we don't have friendly direct examination. So basically you're finished and we're going to move on to the next witness. I do have that
Thank you,
exhibit.
Your Honor.
You're welcome, sir. I have that exhibit number 2. I'm going to mark it as not admitted with your permission. Correct?
Yes, sir,
Mr.
that's
Simpson?
fine.
Not admitted, not evidence. Done. Moving on to staff, or Mr. Black, are we ready? Let's see. Yes, we're gonna put on Mr. Brandt for CCAE. Is that correct, Ms. Lynch?
Correct, yes.
All right. Are you ready to be sworn in, Mr. Brandt? Turn on your audio, please.
Oh, can you hear me?
Now we can. Mr. Lee, please swear him in.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter not pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Lynch, please, your witness.
Okay. Good afternoon, Mr. Brandt.
Afternoon.
Thanks for joining us. Would you please give your full name?
Justin Brandt. My last name is spelled Brant.
Thank you. And what position do you hold at SWEEP?
I'm co-director of the utility program.
Did you prepare your direct testimony in this matter?
I did.
Do you have a document before you marked CCAE Exhibit 1?
I do.
Is this the direct testimony you prepared?
Yes, it is.
And if I asked you those same questions today, would the answers be the same?
Yes, they would.
Do you have any changes to make to your direct testimony?
I do not.
Your Honor, CCAE moves to admit CCAE Exhibit 1 into evidence.
Thank you. Ms. Lynch, just give me a second here to make sure what I've got is what I think I've got. Okay. I've got the direct testimony of Justin Brand on behalf of Coalition for Clean Affordable Energy dated December 17th. Looks like it's sequentially numbered. Goes to number 29, but then there's an affidavit which would have been number 30 if that were numbered. Looks complete to me. Let's see if there's any objection to admission of this document. First, Ms. Olson.
No objection.
Thank you. Ms. Stevens,
No objection.
Mr. Simpson,
No objection.
and finally, and not least, Mr. Black.
No objection, Your Honor.
All right, you guys are making it really easy. There being no objection, the direct testimony of Justin Brandt is admitted. Is this to be labeled as CCAE number 2, Ms. Lynch?
No, I believe it's admitted as Exhibit number 1.
Okay, that's what I thought, actually, despite my question. So I've just labeled it CCAE number 1, and it is admitted as an exhibit in the case, but now your witness is presented for cross-examination, and for certain reasons I would like to begin with Ms. Olson. Ms. Olson, please, if you choose, cross-examine Mr. Brandt.
Mr. Brandt, I appreciate your participation in this and your testimony. I have no cross-examination for you.
All right, Ms. Olson. Ms. Stevens, any cross?
I do, with just one set of questions. Morning, Mr. Brandt. Afternoon. I think we have met once before, but it's nice to see you. I have a question. I have a few questions for you about your testimony beginning on the bottom of page 9 at line 18, talking about the company's request to include its previous overages, the 2020 plan year overage of $902,101. Were you here present? Were you watching the cross-examination of Mr. Hernandez this morning?
I did miss a small portion of it related to this issue, so I was here for much of it, but not complete.
I'll ask and see where we go. Have you looked at city exhibit number, the exhibit that was presented with Mr. Hernandez's testimony on city exhibit number here? I'm sorry for being disorganized. I just assumed we were here. City exhibit number 3.
Hold on, let me bring that up. City exhibit number 3. Okay,
Got
I
it?
believe I have that in front of me. That would be, it's a discovery, the 12-page
Yeah,
document.
so-
That's a discovery request to CLC 1-1. Is that correct?
Right, and if you would, I mean, I think my answer is going to be that you aren't familiar with this and this, you were not there for this portion of Mr. Hernandez's testimony, but let me give it a shot anyway, get you to the right page there before you say no. It's page 8 of 12 of the PDF document. Have you seen this before?
I did look at it as part of, while you were questioning Mr. Hernandez, but I would say it's not a document that I am intimately familiar with. I glanced at it.
So you were, I think that does indicate you were present for part of the questioning of Mr. Hernandez about the reconciliation question.
Yeah, that's correct.
Okay, so first of all, why did you, even before we talk about this morning's cross-examination, why did you recommend spreading the requested reconciliation of $902,000 over 2 years when the EUERF will be in effect for approximately 3 years under the Commission's energy efficiency rule?
Well, as I said in my testimony, CCAE supports the company's proposal to reconcile the EUERF every year, in which case the values would only, it's my understanding on how reconciliation works in most other jurisdictions, that the amount of the EUERF would change every year. So rather than being in effect for 3 years, it would be a series of, it would change every year to reflect reconcile actual expenditures with actual collection.
And do you know whether that's the practice in the state of New Mexico?
It has not traditionally been it, no.
And has
But-
EPE made a proposal to do that sort of an adjustment in this case?
It's my understanding that yes, they have.
And if they have not, if it turns out they haven't, would you still support 2 years? 2 years, dividing the amount over 2 years rather than 3?
I guess I would have to think through it. I think the changes made to the EUEA that allow, it's not a fixed spending amount over 3 years of 3% of sales, that the budget is allowed to float between 3 and 5%, makes reconciliation the most reasonable option moving forward to change the values. If that's not the case, I believe the company proposed spreading this over 2 years in their rebuttal testimony, and I think we'd still support it. I'm not opposed, I guess, to spreading it over 3 years, but I think for reasons of, wanting to make sure that we're collecting monies that were spent in 2019, which is already a few years ago at this point, as close as possible. I'd still prefer 2 years, but I'm certainly not opposed to 3 years if that's the most, that's the easiest alternative, sort of given the EUERF mechanism.
And based on your understanding of the EUERF mechanism, if, as EP is proposing in this case, if the EUREF stays in effect for 3 years instead of 2 without a change by the company, would that mean that the company would recover approximately $1,350,000 for that $900,000 reconciliation amount?
I'm sure there are ways to do it otherwise, so I don't know.
And I think that's, since you're not familiar with this document, this supplemental, this CLC3, I think that's all I have for you. Thank you, Mr. Brandt.
Thank you, Ms. Stevens. Who wants to go next? Mr. Black, any questions?
Staff has no questions, Your Honor.
Mr. Simpson?
No questions, Your Honor.
Miss Lynch isn't going to cross-examine this witness, is she? Ms. Olson, did you have any questions?
No, Mr. Hearing Examiner.
Okay, I don't think there's going to be any redirect, is there, Ms. Lynch?
No, I think he was pretty clear in answering any questions that were posed for him.
Thank you, Ms. Lynch. No recross, obviously, so can we release Mr. Brandt? Ms. Lynch?
Yes.
Okay, Mr. Brandt, you're released. Thank you very much for appearing. We appreciate it. Bye.
Thank you.
And the next witness is Mr. Dunn, your staff, and he has been patiently waiting and enjoying all of these wonderful testimony and things. So I just want to, in case I forget, thank him for actively participating. Mr. Black, are you ready to present this witness?
Thank you, Your Honor. Yes, I'm ready to present the first testimony of Christopher Dunn in his capacity as an economist for the New Mexico Public Regulation Commission. So, good afternoon, Mr. Dunn. How are you?
I need to swear the witness.
Okay.
Go ahead, Mr. Lee. Thank you. I can't hear you, Mr. Lee.
Would you please raise your right hand? You do solemnly swear the testimony you're about to give in the matter not pending to be the truth, whole truth, nothing but the truth?
Yes, I do.
Thank you.
Absolutely.
Your witness.
Okay. Thank you, Your Honor. I'm assuming you're doing well.
Who, me?
Yes, sir.
Yes, you.
Or Mr. Dunn? Well, I don't mind a little bit of levity and informality in these hearings because the air gets so thick, you know, we have to cut it in half with a knife. So it's good to lighten it just a little bit. I'm doing pretty good, I'll tell you. I have a little bit of a schizophrenic, is that the correct word? You know, multiple lifestyle, which we can talk about off the record. And it's good to see a fellow economist testifying. So I'm looking forward to hearing his opinions and things.
Okay.
Actually, I have read his testimony, but I pre-read it, and it clarifies as he's subject to cross-examination. So thank you, Mr. Black, for that informality. Recognizing, I think, that we're definitely going to finish by 5 o'clock. So that's optimistic. With that, I'll just shut my mouth and let you do your thing.
And generally, off the record, which appears on the record, those words, I would use the word frenetic.
Frenetic. Wow, let me write that down. Let's start P-H-R-E.
No, it's an actual F-R.
I think it would have a different meaning with the PH. Wouldn't it?
Perhaps.
Wouldn't, I think that would be like those old things about the brain. thumbs.
Exactly, the shape of the skull.
Yeah,
You're pretty
see,
sharp, Miss Stevens.
We're getting to it.
All right,
Are
all
we on the
right.
same wavelength, Mr. Lennon?
Exactly the same wavelength, Miss Stevens. That's it's interesting. So anyhow, once again, I'm sorry to enjoy the levity. So this is a serious proceeding. So let's I'll try to keep it more seriously. At least I'll try to keep my part a little more seriously. Mr. Black, please examine your witness.
Thank you. For the record, sir, would you please state your name and position with the Public Regulation Commission?
Yes, absolutely. My name is Christopher Elliott Dunn. I'm an economist with the Economics Bureau of the Utility Division of the New Mexico Public Regulation Commission.
Thank you. Have you filed testimony in this case?
Yes, I have.
Do you have an electronic version of that before you now?
Yes, sir, I do.
Can you identify that document, please?
Yes, my prepared direct testimony of Christopher Elliott Dunn was filed on December 17th, 2021.
Was that testimony drafted by you?
Yes, sir, it was.
Do you have any corrections to your testimony?
No, I do not.
If I were to ask you the questions that are posed in your testimony today, would you give the same answers today under oath?
Yes, I would.
Is your testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
Did you sign your affirmation on PDF page number 94 of 96?
Yes, sir, I did.
And with that, I believe, let me just check my notes here. Mr. Hearing Examiner, I tender Christopher Dunn, staff witness, for cross-examination at this time.
Did you want to move
And I
an
offer his
exhibit?
I offer his testimony as an exhibit to be marked by you.
Well, I'll not only mark it, I'll introduce it as, I'll admit it as evidence, especially I'll admit it as evidence if there's no objection, but I'm not going to presume that. I'd rather just put it on the record if I hear it from each party. Ms. Olson, is there any objection to admission of Mr. Dunn's direct testimony?
EPE has no objections.
Great. And Ms. Stevens?
No objection. Oh, I do have a question though.
Yes, what is it?
Is there a marked version floating around? Because I don't think I received one on Monday. I went back to the original filing date.
I hearken back to my comments on the first day that the procedural order did not order any of the parties to pre-file any exhibits or list any exhibit lists before this hearing, so staff did not do so.
Okay.
Well, just to be clear, I asked that the potential exhibits be circulated among the parties. I don't remember exactly how I stated that in the order, but I think one of my colleagues,
go ahead.
One of my colleagues likes to use Dropbox and tells everybody to dump their stuff in Dropbox. And I don't know, I just don't like that. I think it can be done less formally just by sending out emails to each other.
I believe I misunderstood that it was already filed on December 14th in the docket, and I assumed everyone had access to that.
That's a relatively good presumption. We all can look on eDocket too. But did you actually send it by email to everybody, Mr. Black, when you file it?
Oh, it was served to everybody on December 17th.
Yeah, that's what Ms. Ramirez certified to in the certificate of service. So it's out there. Is there any question about what it consists of, Ms. Stevens?
No, as long as that's the one. That is what I went to that filing. I just wanted to make sure I hadn't missed a recent one.
Hearing Examiner Lennon,
Yes,
there's a source of confusion, and I happened to notice this actually when I was looking at your email. I think Mr. Black was inadvertently omitted from that email that you sent requesting the parties circulate exhibits. So I think that is the source of this confusion.
No kidding. And Mr. Black, don't you check eDocket every day to see if I filed anything? You
Usually,
don't?
yes, before a hearing.
Okay. I'll confess to you guys, I do the same thing. I pull it up and take a look at it. So we're all getting nice and comfortable and warm and loose in this hearing.
Yeah.
But I do appreciate that as well, especially late in the hearing. Imagine if it was a 10-day hearing, how crazy we'd be by the end of it. Anyhow, is there any objection to admission of the direct testimony of Mr. Dunn by Ms. Olson? Did you already tell me? No objection.
No objection.
Thank you. Mrs. Stevens
No objection.
and Ms. Lynch,
No objection.
Mr. Simpson.
No objection.
All right, so I don't have to make a decision. There's no objection. The motion to admit is granted. Shall I label this staff number 1, Mr. Black?
Yes, please.
Okay, as you can see, I literally write just that on my paper copy. So as we're required, Mr. Dunn should be now subject to cross-examination from all parties. And since the applicant is the moving party, I would ask that Ms. Olson begin the cross-examination.
And Mr. Dunn, I thank you for your thoughtful analysis and your testimony. EPE has no cross-examination for you.
Well said, Miss Olson. Miss Stevens.
Good afternoon, Mr. Dunn. I think we've been on some calls previously, but I think it's the first time I've actually met you in video. Maybe one of these years we'll see each other in the flesh. So I do have some questions that are similar to the ones I just asked Mr. Brandt. Why did you recommend spreading the requested reconciliation, past reconciliation of $902,001 over 2 years rather than 3?
Certainly. And addressing that question, I would point out that my testimony doesn't actually advise that the reconciliation is spread out over 2 years rather than 3. Instead, the way that I approached this matter was looking at the overage and reconciling that amount in such a fashion that would attempt to minimize any overages or underages on a monthly and annual basis. Because if the Commission elects to impose carrying charges on any future overages or underages, then reducing those overages or underages will reduce costs for the company or for the ratepayers that would be associated with carrying charges. So I kind of came at it from a different approach. Now, it just so happens that my approach, the one that I ultimately landed on, did correlate to a similar proposal made by CCAE witness, which recommended it be spread over 2 years. My methodology in reaching my recommendation was different.
Would you look, I'm at page 49 of your direct testimony, as I'm sure you know, but the others don't. So when this is, does staff, the question is, does staff propose an alternative EU ERF for the Commission to consider? And can you explain, you've got you've got the total recommended EU ERF of 4.35835%, and then you have the component parts. I think are those meant to parallel what Mr. Hernandez, how Mr. Hernandez's exhibit was structured? Or are you suggesting that the actual line item on the bill be broken down into the 4 component parts?
Those are meant to parallel the proposal that was made by Mr. Hernandez in his original testimony. And that can be demonstrated in the accompanying exhibits of my testimony.
And the item number 4 there on line 9, the 0.028585% to reconcile that is based on taking the company's original proposal and divide up, which was for a 1-year reconciliation, and dividing it in half. Is that right?
That is accurate.
So what is staff's position as to whether it would be appropriate for the company to continue to collect the proposed, your proposed EU ERF of 4.35835% after roughly the second year, when that reconciliation is fully recovered through that percentage portion?
Staff looked at the proposed reconciliation that was offered by Mr. Hernandez using EPE's recommended EU ERF. That recommendation resulted in significant overages through time. And so rather than coming with that approach, I looked at it as to find the most appropriate EU ERF that would ultimately reduce overages or underages for all parties. I observed the fact that historically the EU ERF of the company has been static across the triennial plan. And so my recommendation was not limited to a particular perspective of, does this go into year 1, year 2, year 3? It was based off of the initial standpoint that the EU ERF would be static, and I made my determination from that point. The exhibits accompanying my testimony show what the EU ERF would result in terms of overages and underages throughout the different plan years, and I found that my EU ERF, as seen in, and I'll try to find the appropriate area of my exhibits. Exhibit CED 6, page 303, shows a greatly reduced over collection by the company compared to their EU ERF. I hope that addresses your question.
Does it make it, yeah, and I'm sorry for not having studied your exhibit closely enough. Does it make a difference whether or not you've used a flat annual, month, you divided the monthly figures into just 12, the same amounts of each month? Does that make any difference in your end result?
Absolutely. And that's why I have included staff exhibit 5 and staff exhibit 6 in my testimony. Those are a comparison of the ERF that EPE has proposed in staff exhibit 5 on an average, using average monthly expenses based on historical averages that were calculated in exhibit CED 4, I believe it is.
Mm-hmm.
And then similarly, exhibit CED 6 again uses average monthly expenses based off historical average monthly expenses, again calculated in CED 4, to look at how the overages or underages would shake out on a monthly and annual basis that is demonstrated in CED 6.
Okay, thank you.
Absolutely.
So that's where you get at the end to the 8,000 figure, which is pretty minimal.
I'm sorry. Can you speak up, Miss?
Oh, so I'm looking at the last page 3 of CED 6. When you do it on a monthly basis, you end up with a fairly nominal over collection of $8,743. That's over 3 years, right?
That is the cumulative amount at that time, correct?
Okay. Thank you. And were you present for my cross-examination of Mr. Hernandez this morning?
Yes, I was.
So have you looked at CLC Exhibit 3, which
Yes,
is the estimates for 2021? Does the fact that the $900,000 over collection shown at the end of 2020 seems to be less at is less at less, I'm not saying not an under collection, but is less as of 2021, does that alter any of your recommendations?
No, it does not.
Okay, thank you. That's all I have. Appreciate your testimony and your work in the other cases.
Absolutely, thank you.
Thank you, Ms. Lynch. Any cross?
I do have some cross-examination only because I'm hoping Mr. Dunn can help answer some questions that I have that were raised.
We don't have friendly direct, with the other witnesses, so I'll be kind of listening for that.
Okay. Were you present during the cross-examination of CLC's witness, Mrs. LaRock?
Yes, I was.
Okay. And during her testimony, she raised a concept, field confirmation. Do you remember that?
I do recall that discussion, yes.
Are you familiar at all with field confirmation?
Only insofar as it's been discussed in this case and in regards to its relevancy in this matter.
Okay. I'm just wondering if within the implementation of a plan such as the one that's being proposed, are there safety valves or measures built in place to assure that the programs are having an energy savings effect?
I would, in response to that question, I would answer that the state-appointed measurement and verification evaluator is likely to be the most appropriate check to ensure that these measures are implemented and verified effectively.
Okay. And then just based upon your opinion, if we were looking to strengthen field confirmation measures, the best approach would be to take that solution to the legislature, or do you as an economist see opportunities to incorporate measures financial measures of the effectiveness of certain programs. For example, the lighting program. Are there ways to tighten up the effectiveness of that program?
Ms. Lynch, I have to respond in that your question regarded the best approach to be recommended, and I do not have sufficient knowledge at this point, nor have I studied this matter effectively myself at this point to be able to make recommendations of the best approach.
Is that topic in your direct testimony, Mr. Dunn?
No, sir, I do not believe it is.
So I'd ask that the cross be limited to topics which are in the direct testimony, please.
Thank you. I just wanted Mr. Dunn to, I guess, expand upon the field confirmation concept that was raised in Ms. LaRoque's testimony. I appreciate your testimony, Mr. Dunn, and your time. Thank you so much.
Thank you, Ms. Lynch. Mr. Simpson, any cross-examination?
No, sir. Thank you.
Thank you. Then I think we're finished with cross-examination. Mr. Black, there could be redirect within the scope of the cross. Any?
No redirect, Your Honor.
Great, and there'll be no recross. So Mr. Dunn has been here. He was the first to check in actually yesterday morning. So I'm sure he wants to stay, and we'll just keep him here. And especially since I believe he could be the end of this testimony today. Am I missing anything? Is there anybody else that needs to present some testimony? Ms. Stevens looks like she has something to say.
Oh, no.
Oh, no.
We're done.
That's what I'm afraid to say that.
Big smile, big smile.
I'm
We're
really
done.
afraid to say
And
it.
it's not even 4 o'clock.
Amazing. I was a little, well, anyhow, Ms. Olson, do you have anything else to present testimony-wise? Nothing?
No, Mr. Hearing Examiner, we have nothing else to present.
Just to make sure, Ms. Lynch, Ms. Simpson, and Mr. Black, you also have nothing further to present in testimony, right?
That's correct.
Correct.
Nothing more.
Correct, Ms. Lynch, and correct, Ms. Simpson. Okay, great. I don't have anything else to present. At the end of some hearings, counsel for parties want to do oral closings. I presume that you guys will want to do some sort of written closing. So we might discuss the format thereof and the date it would be submitted. But correct me if I'm wrong. Ms. Olson, I take it you don't want to do an oral closing, is that correct?
No, I do not want to do an oral closing.
Do you intend to do a written closing? I do believe they're optional. I mean, you need not close a case. I also call them summations. So if I'm looking for that, I'm looking for a willowing, if you will, of the evidence down to the relevant facts and then the orientation of the facts to each other, and typically in a way which is advantageous to your client. And that's what I look for in a closing. So do you plan on doing a written closing, Ms. Olson, representing the applicant?
Mr. Hearing Examiner, I'll defer to your direction. I don't know. You obviously were very well prepared for this hearing. You're familiar with the case. You're familiar with the testimony. Hopefully the cross-examination that was elicited on the few contested issues was helpful to you. I always find it helpful if the hearing examiner gives direction on specific issues that they may be struggling with and requesting briefing on. If other people are going to have last word, then EPE would obviously like to have a last word too, but I don't want to write something just for the sake of writing it. I want to do something that would be helpful to the decision maker.
Well put, Ms. Olson. Ms. Stevens, do you have an opinion on doing a written closing?
Mr. Hearing Examiner, I assume and expect and would like the opportunity to do written, closing briefs. I think that'll be helpful. And usually we do them simultaneously. I don't know whether that works for you. Probably when this is sort of a round robin type case, that may be the only way to do it. But yeah, I'm ready to set a schedule for written submissions.
Well, as you guys probably notice, I like to do things collaboratively with the council. Ms. Lynch, do you concur that there can be written closings?
Yes. I just want to clarify, is that also what a post-hearing brief is?
Yeah.
Okay.
Yeah, exactly. I don't always use the correct terminology. To me, they are summations done at the close of a trial. Around here, we call them, post-hearing briefs, which to me sounds like an appellate type document. So that's why I probably don't use that word. And to me, this is the equivalent of more of a trial court, which would do a closing argument, also known as a summation. And in this case, it would be a written closing argument or a summation. Just so you get inside my head a little bit and why I'm using different technology. So
I appreciate that.
Yeah. Well, thank you. Mr. Simpson, closing brief okay for you? Need not be extremely formal, by the way, because you're a pro se litigant.
Yes, sir. I was expecting to do one of some sort.
Okay, thank you. Mr. Black, do you concur?
Staff concurs for the parties to be able to voluntarily or optionally file a closing brief in this case.
Okay, thank you. Yeah, I think it is kind of optional, but everybody seems to grab the ring and run with it. So let's first of all, now we don't need to do oral closings, first of all. Second, we will do written closings. Now let's agree to, and then I'll more or less mandate when they'll be due. I do think they should all come in at one time. I do think it should be 5 p.m. local time on AKA COB or close of business. So we just need to pick a date. Are we up against any kind of deadlines that you guys remember in this particular case as to when the commission needs to order? Anybody know that? So I don't know that either. I think not. Although we do need to generally move with deliberation, not to postpone anything. So let's see how much time we might need. Today is the 12th. I can't imagine you guys could pull this together in 2 weeks. Do you, let's just throw something out there. I'm also looking at my hearing schedule, frankly. I have a hearing on the 15th through the 17th, which I'll probably prepare for on the 10th, 11th, and even 14th, believe it or not. But if you guys want to set a deadline of the 9th, that kind of works for me, and that may be enough time. We have to, if you guys want to refer to the transcript, we're going to need the transcript in our hands to do cites to the transcript. So I believe Mr. Lee probably would have it to us in a couple weeks or so. Is that right, Mr. Lee?
Yes, sir.
So a couple weeks from now would be the 26th. And if we made it to 9th, oh my, that would be 2 weeks. 3 weeks sounds more reasonable. Shall we say the close of business on the 16th? Any objection to that?
I'm sorry, did you say? I'm getting confused with my calendar here, January and February. So 2 weeks is the 26th?
Well, 2 weeks after the transcript is expected would be the 9th. And that just sounds like we're pushing it a little hard. So that's why I proposed the 16th. And frankly, I'll be in a hearing on that day. So I won't be actually even reading them on that day. And that's the deadline. It doesn't stop you from submitting them earlier either. But I'm all ears. Has anybody else got any other really good ideas that I'm missing?
Mr. Lennon, if you would consider doing it a little bit later, I'm flipping through my calendar here and seeing that the initial post-hearing briefs in case 21-00064 UT, that's the EPE February 2021 fuel clause case that you heard in at the very beginning of December, end of November. The deadline for those briefs is Friday, the 11th of February. So rather than have to pick up again and start writing a brief on a weekend, if you're in hearing, could you make it the 18th or the 21st, if it doesn't matter to you?
Yes, Ms. Olson, you have an opinion on it?
Briefly respond to that. I was a little bit confused by the comment that you started with on, is there any looming deadlines? And so I just wanted to throw out there the consideration with the conversation we had earlier about the extension.
Hi, well, she's,
Oh,
of course.
that's right.
So very much there is. Thank you, Ms. Olson. I knew there was something that was bothering me. There was something. It just didn't clarify in my mind. And I wanted to mention, I had by the way, I contacted the commission only through the Office of General Counsel. And I know we're still on the record, Mr. Lee, and of course we're still on YouTube, but I don't mind, this is transparency. I don't mind telling you, I sent an email to the General Counsel for the commission as to either issuing another suspension of the tariff or extending the current one, which it's a slight distinction, but there is one. And I have not yet received a response, but that's not unusual because today was hearing day. And on hearing day, basically the focus is on the public hearing of the commission, including the Office of General Counsel. So I suspected I would not hear back from them. I will be communicating with all you guys by email about that. And hopefully there ultimately will be an order to distribute, but it doesn't exist yet. So I'm not going to presume anything or even Office of General Counsel's position on it. But especially since Ms. Olson has no response, no objection to what I think was a reasonable extension were your words. I think we can hold it to a reasonable extension. My idea was that a reasonable extension sounds a lot like 60 days to me, which would take it to the end of March-ish at some time, or endish of March. I'm coining words as I speak. So that being the case, we still need to get it to the commission by the middle of March, RD, and I need to write an RD by the beginning of March. So I would need these in my hand by the end of February, which is once again, kind of like, I guess the 23rd or so. So 23rd kind of still looks like a pretty good date.
And hearing examiner Lennon, not to complicate things, but would you afford an opportunity for response briefs, or we're just talking about?
Sure, but then a response to a response, and it starts to get kind of weird. And if I don't give one, then you got to do what lawyers do on closing when they waive the closing and then just do the reclosing, and they anticipate what the other guy is going to say or something like that. I know you've probably all been through that. I don't have a strong preference. I think that you should be able to put into the closing a summation of how you have proven and how the other guy has not proven their case. And so I really don't think a reply brief is necessary. I'm willing to hear from all of you if you strongly feel that you want to do a reply. So it sounds like you might want to do a reply. Is that correct, Ms. Olson?
Again, I want to do what's most helpful to you to make a decision.
Yeah, okay.
Sometimes a one person summation and another person's summation are totally different. And then you're kind of curious what their response is to the issues raised in one brief.
Well, I don't decide the cases on the summations, by the way.
Sure. And that's why I kind of hinted at, if there's a particular issue that you feel like you're struggling with and you want that briefed, I think that can oftentimes be more helpful than just regurgitating what's in the pre-filed testimony, what people said on the stand.
Yeah, I don't really need that. I don't mind cites to the transcript, and I don't mind cites. And I also like, by the way, copies of your summations in Word. So if I like a paragraph and it's useful, I can literally take it and cut and paste it into the RD. I don't always do that, but it's sometimes useful. But I think, like I just said,
Mr. Lennon?
yeah, I like just a summation without a reply. Go ahead, Ms. Stevens.
Would a reasonable compromise be to have the response briefs due like in a matter of days so that we're necessarily keeping them short and kind of pithy and responding to, very specific misstatements or clarifications of the record as opposed to new arguments?
Are you talking about lawyer incentivization?
No. Well, which way?
Disincentivization.
This is disincentive or incentivization. I think that it would be probably better to have an opportunity, even a sort of an abbreviated opportunity, rather than to suddenly have you being, particularly if you're going to be in hearing yourself, having people file a desperate motion saying, you have to give me an opportunity to reply. That's the sort of circumstance I'm contemplating. I think we do this. It's like filing rebuttal. Or quickly, shortly before the hearing. It's like, you're about 90% certain, but you don't want to close the door altogether.
So you want to reply to?
A quickie reply. I think my suggestion is sort of a quickie reply.
Ms. Lynch, you've been nice and quiet. Do you have any opinion?
I thought we were waiting for Mr. Lee to produce the transcripts so that those of us who need to rely on the transcript can go back to those. In this instance, perhaps it would be best for us to do a combined reply brief, and on any issue that there's divergence, the parties could submit their own reply brief. That's a possibility.
Okay, well, when I get these briefs, there's not very much which is in agreement very often between the applicant and the interveners. So I don't expect them to be anything. I don't expect that much convergence, frankly. The parties take different positions. Well, I'll tell you what I'm going to do. I haven't been convinced by any of you that I should do something different. I'm going to ask you guys to do a written brief, and it's going to be due on February 23rd at the close of business. Do strive to be succinct if possible. I don't think there needs to be a reply brief. If you want to anticipate what the other party is going to put in their brief, I think that wouldn't be so difficult to do. And you might put a couple pages of that at the end of your brief. That's some sort of response to Mrs. Stevens' suggestion that we would do some sort of abbreviated response brief. But like I said, I consider it just even an unnecessary part of the hearing, but I want lawyers to have an opportunity to close their presentation with a summation, argument, whatever you want to call it. I don't think a reply is necessary. So I'm going to write down that it's due on the 23rd of February. Like I said, succinct is good. Hit the main points. I always say hit the elements. First, identify the elements. Explain where in the transcript or where in the admitted documents you have satisfied each element. If you want to argue some sort of public policy, you are welcome to do that. I seem to be feeling some public policy vibe to the evidence, so you might want to address that kind of a thing. By that I mean like public interest policy, and then there was essentially references to legislation and even federal legislation and references to legislation does not yet exist and that type of thing. As it becomes farther removed from today's reality right here, rather than what we want or what might happen in the future, the less valuable that type of evidence and the less valuable that type of argument is for me to write a RD for the commission to consider. So anyhow, I've given you a little bit of insight into what goes around in my head. Are there any questions about that deadline or anything else?
Mr. Hearing Examiner, this is David Black for staff. In an effort to recognize your desire to have succinct closing summaries, I've not seen it, but other courts do it, federal courts especially. Would Your Honor consider a page limit on these?
Yeah, I consider that, and then I get single page, single, what do they call it? Single line. You know, I'm just kidding. And then the margins expand just a little bit, and then there's no room for the numbers on the bottom of the pages. Then we go to the back of the page, and then I only end up reading 50% of it because I don't look on the backs of the pages. You know, so yeah, I would consider it, but I trust all you guys. You know, you're all members of the bar and we respect each other. And I believe that a page is double spaced unless it's necessary to cite a statute, where you might single space it and indent it just a little. There are certain conventions that we all follow. So I expect double spaced. I don't have a limit, but when I say succinct, there better be a pretty good reason if it's going to be a 50-page closing. I'm not saying I'm going to stop reading at page 17, but you know, if you want it to be an effective document, it behooves the drafter of the document to make it effective. And effective documents typically are succinct documents. That's just the way I see it. And so page limits, there are lawyers that get paid by the hour, and I don't think you're one of them. I mean, by the page, Mr. Black, pardon me. And if there's a 54-page limit, they're going to write 53. And
I used to call that get paid by the pound.
Pound, page.
I forgot
No
how
more
much.
paper.
Well, in the old days.
Nothing to weigh anymore, right?
Yeah, in the old days, how much was a raft of paper? How much did that weigh? A raft.
So I don't want a page limit to answer your question. Are there any
Okay.
other comments? Reasonable, using Miss Olson's terminology. And it's the reasonable man standard is something lawyers spend their lives defining, of course. So anyhow, reasonable is the page limit. Any other comments before we close for the day?
Mr. Hearing Examiner, I'm not trying to be difficult or cause issues. I just want to make sure that this schedule is allowing you sufficient time. I'm just a little concerned that if our brief is due on February 23rd and we're expecting a final order from the commission on either March 23rd or March 30th, you haven't allowed a tremendous amount of time for you to, one, write an RD, and two, allow for potential exceptions, and then three, allow the commission to consider an RD and exceptions and make a decision at an open meeting. I think I may have lost you.
I think he's frozen.
He's gone.
I think did you say, when you said lost, Carrie, when you said lost, did you mean lost in following or lost as in lost in
I'm off the record.
cyberspace?
Literally lost him.
You caught the fact that he was literally lost.
Yeah.
First.
I hope my comment didn't drive him over the edge.
We'll have to just wait for him and find out whether his own link still works.
Perhaps I can issue a ruling then.
Take over. Are we off the record now?
Yes, we are. We're off YouTube
Yeah.
too.
Either of the Davids, do you have any way of seeing, or Christopher, do you have any way of seeing better what's going on with the, technology at the commission than the rest of us do?
Well, Christopher's in Las Cruces and I'm in
Oh.
Santa Fe.
Oh, that's right.
I know Mr. Lennon has previously had a challenge with internet service that
With his
he's
internet.
correct within a hearing. So maybe if
Yeah.
we get a moment, it'll pop back on.
I don't have his phone number or anything. I could find it, I suppose.
He may be trying to email people, so you perhaps may want to check.
All
Yeah,
right.
my email is so full of stuff because of that rulemaking today. I'll go, it's probably backed up for hours. My Gmail says that I have 27 items. My new unopened items in my email. That's what happens when there's a rulemaking. But nothing from him.
I'm just gonna step out of my chair, but I'll be within earshot.
Okay.
Carrie, I've got to ask about your background today. Is that an electronic one?
No, I think it's this has been like a source of constant comments and laughter, but the light is comes in the room really awkwardly, and so sometimes it creates interesting geometric shapes on the back. Sometimes it blinds me. Sometimes I'm blurred, and then one of my colleagues has been in here duct taping things to the windows and moving chairs, and I don't know it. It's been interesting, but yeah, it's just the lighting. It's just we're just in, or I'm in one of my conference rooms, and it's just a white wall behind me. But
Oh, that's really wild. It looks like.
yeah, yeah, we don't usually use this
Is that particular room?
hearings, and now I know why, because it gets really warm in here in the afternoon, and then the lighting gets kind of crazy.
That was admittedly my thought.
I don't know. We're all still online. Did you want me to just put the phone on speaker and you can talk to us all?
You found it.
Yes.
Sounds like he's on someone's phone.
Okay, so let me put my speakerphone on and we can just have a chat, shall we? Okay.
Make it loud and proud, Mr. Black.
Okay. Okay, Mr. Lee has gone off the record, but you can advise him as to what your desires are. Let me put you on speaker. Oops, hold on. But there we go. Now.
Hi everyone. This is Bob Lennon. Mr. Lee, are we off the record at this point?
We are back on the record right now, but we were off the record.
Thank you. I'm back. We're back on the record, and I think we were just closing. I mean, we were like almost finished. Honestly, I have no idea what's going on. My internet seems to have simply disappeared. And the fact that Mr. Black is still on, and are you down at the end of the hallway, Mr. Black, or are you at home?
I'm working from my home office.
Okay, so that doesn't explain it. So it's possible the PRC internet is down, or maybe just my office. I really don't know. I'm actually at the Bochum building downtown in my PRC office, but I have no internet, and I have no idea what happened. I just simply do not know. What happened is, as soon as I lost everything, a little thing starts spinning in the middle of my screen describing that it's trying to reconnect, and it never could. And then, of course, I started trying different things, and then I started trying to email all of you guys. So I think I'm ready to conclude. I think we are expecting the briefs at the 23rd, on the 23rd. That gives me, if everything works as planned, a couple weeks to write a recommended decision. And I believe Ms. Olson was concerned about whether it left enough time for me. A couple of weeks is plenty of time if nothing else interferes. And even if other things do interfere, which they always do, it's a couple weeks is enough time. And I believe Mr. Black stated he could have a transcript within 2 weeks from now or so, which would be the 26th. So that would be enough time for you guys to do your closing briefs. So I'd like to get this over with more quickly rather than less quickly. So hopefully no one else has any further comments, but if you do, please speak up right now and identify yourself first. Silencio, excellent. I hear nothing. So I'm going to presume that there's no further comments. I'd like to also adjourn this hearing. And I thank you all for all your cooperation. It's now 4:13 p.m. And I apologize for this little blip at the end. I actually have no explanation once again, but I apologize for it. I'm going to ask one more time. Is there any reason? Oh, I'll keep everybody informed of the other issue about the extension. Is there any other reason we need to continue with this hearing now? Please comment if there is a comment or a response. No. Very well then. The record is closed and we are now hereby, the hearing is now adjourned. Thank you, everyone.
Thank you, Your Honor.
Thank you, Mr. Lennon and everybody else.
Thank you.
Thank you and have a wonderful day, you guys. Take care.
Thank you.
Bye-bye.
You.